Be cool, be kind, be classy. The cupcake's so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
All right, can you hear me now? I don't know. I did something. I you know how much I hate being late, but I was adjusting my microphone and I just like broke the arm of this tripod here. I don't know what I did, but hopefully you can hear me okay. Because the new army is here. The new army is here and they're coming out guns a-blazing, and you can't even imagine the ammunition that has been brought out today. It is like duck around and find out, my friends. Duck around and find out. For those of you who don't know, Mark Betterow has joined the defense team for Karen Read. They filed a motion yesterday, or it hit the docket yesterday. I think it was dated before that. For Mark Betterow to be admitted pro hoc vice on the Karen Read case. So for those of you who don't know, when you're not admitted to the bar of a certain state, like Massachusetts, you need to apply for a pro hoc vice admission for each case that you want to represent a client in. So while he was already admitted in the Aiden Carney case, he now needs to be admitted in the Karen Read case. So he has joined the defense team. And it coincidentally hit the docket yesterday when the same day that the Supreme Judicial Court appeal decision came out, which did not go in Karen Read's favor. But the silver lining was that we found out that Mark Betterow was joining the defense team. And it's sort of like a little bit bittersweet for me because I love having him as my co-host. I love having him as my voice of reason when I think I'm being gaslit, so that he tells me that I'm not crazy and that my instincts are right and that everything here is completely upside down. We're in the Matrix. We're in the, I'm calling it Narnia because it reminds me of like The Lion, the Witch, and the Wardrobe. And it's bittersweet for me because he cannot come on the show anymore to talk about this case. But I'm still here and I'll be yelling into the closet and you guys are still here. And we still need to talk about all this stuff because while he's working on it, we need to report on it. So we're still going to be here doing it. And that's exciting because they're not messing around this time. They're not messing around. Guns are blazing. Lasers are coming in. They've got lasers coming in to do laser measurements and accident reconstruction of the accident that occurred in the One Meadows Driveway when Karen's Lexus hit the Traverse. And they want access to the Lexus and the Traverse, and they want to send an expert in there to do laser measurements with his laser, and they want all kinds of things and stuff. They want James Crosby, the expert that the Commonwealth has exchanged, who's a behaviorist and animal behaviorist. They want him out, excluded. Dr. Russell has submitted an affidavit in support of that motion, saying this guy is nowhere even near qualified to testify about the injuries on John O'Keefe's right arm. In fact, Your Honor, and I love when they do this, they transcribed her own words against her during the last trial when she told Dr. Rentschler, no, you're not a medical doctor. You're not allowed to testify about the injuries sustained by John O'Keefe because you're not a medical doctor. Well, they took her words and they used them in their motion to say that this Dr. Crosby that's been hired by the Commonwealth is not a medical doctor. How can he possibly opine as to whether or not the injuries on John O'Keefe's right arm were caused by a dog? He can't because he's not a medical doctor. We have that motion. We've got, believe it or not, you guys, just when you didn't think that the cops in this case could get any more stupid, they're stupid. They're more stupid than you even imagined. Proctor, despite the fact that he was cross-examined with his cell phone records and his horrific text messages during the last trial, was still texting by July 1st. And they've got more text messages from Proctor. And then, not only that, it gets better because it's not between Proctor. It's not just Proctor. It's between Proctor and Lally. Yeah, Proctor texting Lally. So if you didn't think that Lally may already be called as a witness in this case, he most certainly may, in fact, be called in a witness in this case now because of the text messages between Proctor and Lally on July 1st. Yeah. Oh, but that's not all, because then there's Yuriy Bukhenik. And Yuriy Bukhenik, apparently, Chris Albert has the fast pass to Yuriy Bukhenik because there's text messages between the two of them, too. Text messages between Yuriy Bukhenik and Chris Albert. Not only are there text messages, but Yuriy Bukhenik screenshotted those text messages and then attached them to a police report in another matter. So there's that. Just when you thought people couldn't get any dumber, wait, there's more. There is more. There is more. And today's my birthday. So this is the best birthday present that I could ever have. It's being here with you guys, talking about all this stuff, because it is fire. It's fire. And then also now the defense wants to not have to turn over all of their impeachment evidence to the Commonwealth before the trial, because that gives the Commonwealth the opportunity to then prep their witnesses for the stuff that they're going to be impeached with, which is really kind of ridiculous. I don't know why they would have to, but here we are in Narnia, the Matrix. We're in the upside down. Thank you for the happy birthdays. Thank you. I've been fielding calls all morning, so I haven't been able to get to this stuff, but I did redline a bunch of it. I'm sure more stuff is going to come in while we're on, and we're just going to keep going. So settle in, get comfortable, get yourself some hydration because you're going to need it. And Mark is going to mop the floor with these troopers. That's the thing. I think that's Mark's forte. Look, everyone who's stepping into this army has a function, right? Different attorneys are good at different things. Mark has a lot of experience cross-examining police officers, law enforcement. That's his thing. That's what he does. Bobby Alessi, we're calling him Bobby now. It's your birthday too? Who said it's their birthday too? I just saw that go by. CM Libby 1, celebrating near Cancun. Happy birthday to us and Abraham Lincoln. Aquarius is the best. And Vinny Politan is also an Aquarius because it was his birthday last week. And also David Giannetti just had a birthday, but I think he's not Aquarius. I think he's whatever comes before Aquarius, like Capricorn. So that's awesome. You get your snacks, get your beverages, get popcorn, get whatever it is that you think that you're going to need to get yourself through this, because we're going. I mean, it's Judy Bloom's birthday too. Are you there, God? Are you there? Are you there, God? It's me, Melanie. Please, God, send help. Are you there, God? It's me, Melanie. Yeah, I'm 29 again. I'm 29 again today. Or 49 again. I'm 49 again. Let's put it that way. Now we know why Liza Little was not in court the other day. A lot of people were speculating, where's Liza? Where is she? She is in LA, in her office, in her stilettos, cranking out the motions. That is what she's doing. And good, because somebody needs to be boots on the ground getting this stuff out. Because the deadline was supposed to be yesterday for the, you're Aquarius too. Aren't we the best? We're the best. Gail's Aquarius too. what was I saying? She kicked off her stilettos. She's at her desk and she is banging out the motions. And we need her to be doing that. She's great on paper. She's great on paper. So today was supposed to be, or yesterday, I think the 11th was supposed to be the original deadline for evidentiary motions, but there are more. I think they've asked for an extension, so we don't know if it's granted yet. And I do have the docket up, but sometimes it times me out, and therefore then I can't look at all of it. But the last thing I have in here is document 500, and I do have up to docket number 500. So I've got, I think, everything to do with you today. But it's like, where do we go first? Where do we even go first? I don't even know if I want to go in chronological order because some of it might be out there already. You may have seen some of it. What haven't you seen? Have you seen the stuff with the text messages between Chris Albert and Yuriy Bukhenik? Because maybe we should go there first. Because good stuff. Let me just see which one that is. Hold on. Let's go to 495. Let's go to 495. We're going to read it all. We're going to read it all. Let's go to 495. Because I think that's the one. Wait, do I not have 496? I may be missing 496. Hold on. I just have to look in my. No, that's not it. Because there's more than one motion to compel, I think. Hold on. Let's do. How do I not have 496? Hold on. Hold, please. Hold, please. $496. Do I hear 496? I don't think I have 496. Let me just check one more place. Hold, please. All right, maybe I'll get that before we move forward. All right, let's do. Let us do. All right, we'll start with an easy one. We'll go in order. We'll starting with 488. This is a Commonwealth motion. Let me know if my sound peters out or anything because my mic is so far from my mouth, but hopefully I can speak loud enough for you to hear me. All right. First thing up is the Commonwealth's motion for reciprocal discovery and notice of any experts. Docket number 488. Docket number 488. This hit the docket yesterday, February 11th. So Commonwealth is asking for reciprocal discovery and notice of any experts, and they're asking for. I'm not going to read everything word for word because my voice will be dead. Some of this stuff is 15 pages. Oh, it's your birthday too? It's your birthday too? Happy birthday, Gina. Some of this is 15 pages long and all of it needs to be read. So some of it we're just going to skim through. This is the Commonwealth. They are looking for the defendant to produce all of this stuff by March 6th. They want all the witnesses' names and addresses. Get the red pen. For anybody they intend to call a witness, a trial, name, address, date of birth, any statements of any individual who they intend to call as a witness, including anything in investigative reports or non-legal reports, any written or recorded statements of any individual that the Commonwealth intends to call as a witness. So if they got any statements from any Commonwealth witnesses, they need to turn those over, including but not limited to such statements contained in defense investigative reports or other non-legal reports. Any promise, reward, or inducement offered to any individual whom the defendant intends to call as a witness at trial, which, pretty sure they didn't offer anybody anything to testify on their behalf. I know that the Commonwealth can say the same thing. Any monetary fee to be paid to a witness. Well, the experts, if the experts are paid, they need to turn that over. Any books, papers, documents, photographs, charts, diagrams, chalks. They call them chalks. We call them trial exhibits here in New York. Those are the things that are on like the science fair type poster boards. They call them chalks. Tangible objects or other material and relevant evidence the defendant intends to rely upon or introduce at trial. Any evidence the defendant intends to introduce or rely upon to attempt to impeach the credibility. Oh yeah, they want impeachment evidence. Okay, this is so, all right, I'm not on Ethernet. There we go, that'll be better. They want impeachment evidence. And this is the next thing that we're going to look at after this is the defense's motion like, yeah, no, we shouldn't have to give you impeachment evidence before your people testify, because look what happened last time. And I've been talking about this, and this is really ironic, don't you think? A little too ironic. Yeah, I really do think that I didn't know about this, but they are arguing now, the defense is arguing, why should we turn over impeachment evidence? Because it seems pretty clear to us that during the last trial, because you had our impeachment evidence, you prepped your witnesses to change their stories, or you tried to get ahead of the stuff that we were going to impeach them with, thereby taking the bang out of our buck. And why should we have to do that? Like, we'll give it to you, but wait until your people testify. After they testify, then we'll give it to you, which seems to be fair. And they give a couple of examples of how that happened. And also, I was pointing out that during the first trial, we noticed, and some of you even went and looked it up. For example, when very important witnesses for the Commonwealth testified, or very important meaning, not credible witnesses or witnesses that were going to be slammed on cross, there would often be, for example, Proctor testified on a Wednesday. I think it was a Wednesday. I think it was a Wednesday. Then Thursday was a day off. Then he testified on Friday. Then there was a weekend. Then he came back and testified on a Monday. And I said, did they plan it like that? Did the Commonwealth plan it that way so that, their witnesses could, catch a breath, think about what they were going to say next? It seemed very odd to me. And it seemed, same thing happened, I think, with Yuriy Bukhenik when the inverted video was shown. And then there was like a day off or a weekend. And then he came back on the Monday. It was really weird. Defense is going to bring that up in their argument. So we will see that. Thank you, my dear. Thank you, my dear. You know who you are. Okay. We'll see that. So they want any evidence. This is the Commonwealth now wants any evidence the defendant intends to introduce or rely upon to attempt to impeach the credibility of the Commonwealth's potential witnesses. And they also want expert evidence, which is the name and address, date of birth, and CV of any of their experts, a complete statement of all opinions to be expressed and the basis and reasons for such opinion. This is all pretty standard. All notes, reports, raw data, materials relied upon that form the basis for each expert's opinion. You're correct. They are not supposed to talk to anyone while they are on the stand, even during breaks. You are absolutely correct. Ali Guz. Yeah. Once they're under oath, they're technically on the stand and they are a sitting witness, and they are not supposed to talk to anybody, not a lawyer, nobody. Right. And that's why I thought it was really fishy. Wasn't accusing anybody of anything, but I just thought it was really weird that the very important witnesses that were going to be slammed on cross seemed to have days off in the middle of their testimony. Go figure. All compensation paid or requested. This is all standard for experts, including case preparation, testimony travel, even if not paid to date. Any contracts, agreements, or documents discussing any compensation. But this says compensative. I don't know what compensative is, but a copy of all testing and results, regardless of whether the witness will testify to that information at trial. Any and all results or reports of physical or mental examinations conducted by any person, or scientific tests or experiments, including results or reports of expert witnesses the defendant may call at trial, within the possession, custody, or control of the defendant or persons under his direction and control, that are material and relevant to the indictments or that the defendant may use or introduce at trial. Written notice of whether the defendant will rely upon any defense of lack of criminal responsibility due to mental disease or defect. Stating 1, whether the defendant intends to offer testimony of expert witnesses on the issue of lack of criminal responsibility. This is if you had an insanity defense. That doesn't apply here. And then they say, to prevent, quote, trial by ambush, the Commonwealth is entitled to reciprocal discovery from the defense by March 6th, 2025. And then listen to, Hank throws this little dig in. Previously, the defendant selectively produced reciprocal discovery in 3 increments, one day before the first trial on April 15th of 2024, then during trial on April 28th, 2024, and May 5th of 2024. As the Commonwealth is entitled to a fair trial, all reciprocal discovery shall be ordered to be produced to the Commonwealth by March 6th of 2025. Really? The Commonwealth is entitled to a fair trial? Is that in the Constitution of the United States of America? I mean, I know that the defendant is entitled to a fair, or at least is supposed to be entitled to a fair trial, but the Commonwealth is entitled to a fair trial, and therefore you need to give us all this stuff. Like, really? I mean, it's wild, right? I mean, it wouldn't be wild if it wasn't so ridiculous. Right? Yes. J.C. Brennan, you're the Commonwealth, not the defendant. So there's that. He doesn't want any trial by ambush. No, 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 no. And then he's got to throw the dig in there about when they gave over their discovery, which is so interesting because, you know, you're turning over inverted sallyport videos in the middle of trial and nobody knows where they came from and you don't have metadata and you won't give us the metadata. And in fact, he wouldn't give them the metadata. So we reviewed another motion that the defense had to make because Hank Brennan would not give the defense the metadata. So that is the first thing up. That is docket number 488. They want all their reciprocal discovery, including impeachment evidence. That one is not that interesting. Let's see. Let's go to something that goes kind of hand in hand in this. And this is docket number 493, docket number 493. This is defendant's motion to reconsider the reciprocal discovery order. Talk amongst yourselves for 1 second while I just get a little sip of a drink. Hold on. All right. I feel like my throat is all raw today. It's like I smoked a whole carton of Camel no filter cigarettes. All right. I don't smoke. I used to smoke, but I think we all used to smoke, you know, in high school back in the day. Defendant's motion to reconsider reciprocal discovery order. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to reconsider its reciprocal discovery order regarding the defense pretrial production of impeachment evidence related to the Commonwealth's anticipated trial witnesses. Let me make this a little bigger for you. As grounds for this motion, the defendant states that production of impeachment evidence prior to witness testimony is not required under the Massachusetts Rule of Criminal Procedure number 14, which, interestingly enough, has just been redrafted and is scheduled to take effect, I believe, on March 1st of this year. And also, Judge Canoni was the head of that committee to redraft Rule 14. And it addresses everything lots of things, I'll say, that the prosecution tried to pull in the first trial of Karen Read. I think it was precipitated by the persecution of Karen Read, in my opinion. All right, moving on. As grounds for this motion, the defendant says that production of impeachment evidence prior to witness testimony is not required under Massachusetts Rule 14 and will unduly prejudice the defense by allowing witnesses to tailor their responses to preempt cross-examination. The production of impeachment evidence related to witnesses proffered by an adverse party is not subject to mandatory disclosure under Rule 14, and in this case would be particularly prejudicial to the defendant given the public nature of the proceedings and the close personal relationships of many of the parties involved. You know who looked like he was not prepped for those text messages that he was he looked to me, Matt McCabe, like he was completely shocked when those text messages were pulled out and he was asked to read them about, tell them the guy never went in the house. Which is wild to me because since those text messages were turned over during the federal TUI dump, Adam Lally absolutely had them. So why did Matt McCabe look like he was hit by a truck when he was forced to read those messages about tell them the guy never went in the house? And, you know, yeah, they're here. They're at the Asian house. Yep, all that stuff, right? Crazy. Factual background. Ms. Read is accused of the following crimes arising out of the death of Officer John O'Keefe: murder in the second degree, manslaughter while under the influence of alcohol, and leaving the scene of personal injury or death. Ms. Read faced a trial by jury for the above crimes beginning on April 16th of 2024. Can you believe it was April 16th of 2024? Wow. Feels like, I don't know, it feels like yesterday in some respects, and it feels like 5 years ago in other respects. Prior to the commencement of the trial, the Commonwealth submitted a motion for reciprocal discovery and notice of any experts filed on March 21st of 2024 with this court. Paragraph 4 of the Commonwealth's motion requested production from the defendant of any written or recorded statement, as well as any oral statement reduced to writing, of any individual whom the Commonwealth intends to call as a witness at trial, including but not limited to such statements contained in defense investigator reports or other non-legal reports. Commonwealth's motion was allowed by this court, requiring the defendant to turn over evidence intended to be used as impeachment evidence against witnesses called by the Commonwealth prior to those witnesses being called to testify at trial. That's wild to me. On several occasions during various Commonwealth witnesses' testimony at trial, the witnesses subsequently tailored their testimony and included details which had not previously been discussed to account for the impeachment evidence turned over by the defense. For example, at trial on May 21st, 2024, Jennifer McCabe, Ms. McCabe, testified. Please don't use all caps in the chat. It's for mod use only, and it really distracts me. Thank you. Appreciate it. During cross-examination, Ms. McCabe testified that on January 30th, 2022, the day after John O'Keefe had been found in front of 34 Fairview Road, she went to the house of Canton Police Lieutenant Michael Lank. Remember that? Does everybody remember that? Prior to this testimony, Ms. McCabe had never disclosed publicly or in any report or witness interview, even when asked directly about her meetings and conversations in the days and weeks following January 29th, 2022, that she visited the house of one of the responding police officers to 34 Fairview Road. Ms. McCabe, who is, quote, friendly with Mike Lank, according to her own testimony on May 21st, and, quote, knew of him growing up, end quote, according to her testimony on May 21st, testified that she, quote, could have been at Lieutenant Lank's house for an hour. That was also part of her testimony. After initially denying having entered Lieutenant Lank's house during the hour that she was present, she then remarked how she, quote, might have ran in to go to the bathroom, end quote, also in her May 21st testimony. When asked why she had never testified to this incident before, Ms. McCabe responded, quote, I guess I never thought much of it, end quote. The only time Ms. McCabe claimed to have discussed this meeting with anyone related to the case was at the DA's office, May 21st of 2024. She testified to that with, quote, Mr. Lally, Ms. McLaughlin, Steve Nelson, and Trooper Brian Tully. Ms. McCabe confirmed that at that meeting with the prosecution, she was specifically asked about her meeting at Lieutenant Lang's home, something which she had never revealed and about which she had never previously been questioned. At trial, she saved this information for cross-examination. After questioning Ms. McCabe about a different topic, Attorney Jackson asked Ms. McCabe, did anything significant happen on January 30th in connection with this case? Any meetings, any get-togethers, anything that you can think of? Ms. McCabe responded, I went to the O'Keefe's house. Attorney Jackson followed up, other than that, anything else? In response to this open-ended question without any indication from Attorney Jackson regarding the answer he was seeking, Ms. McCabe volunteered this thorough answer. On the way home, Kerry Roberts' daughter is good friends with Michael Lank. So we dropped her off at Michael Lank's house, and Mike's wife came out of the house. Him and Kerry are friends, and she, jumped in the car and was consoling Kerry and asks how the O'Keefes were doing. And, we talked to her. This extremely detailed and comprehensive explanation as an answer to Attorney Jackson's open-ended question, accompanied by Ms. McCabe's testimony that she had been asked about this meeting by Mr. Lally at the DA's office, leads to the inescapable inference that Ms. McCabe was prepared for this impeachment question in advance of trial. Well, yeah, it did, right? Yeah, it does. Kind of seems that way. Gives the appearance of some sort of impropriety. That was only possible because in compliance with this court's impeachment evidence reciprocal discovery order, the defense had turned over location data obtained from Ms. McCabe's cell phone to the prosecution on May 6th of 2024. This location data showed that Ms. McCabe was indeed present at Lieutenant Lank's personal home for approximately 45 minutes on January 30th of 2022. Although the Commonwealth did not elicit this information during its direct examination, Ms. McCabe had clearly been prepped for the question on cross-examination as a result of the defense production of impeachment evidence. But wait, there's more. Another example occurred at trial on May 28th of 2024 when PF, and that's footnote 1, it says PF is used to protect the identity of the minor witness whose information has been impounded in this matter. PF testified in a closed proceeding during trial. PF, who was 11 years old at the time of Mr. O'Keefe's death and 13 years old at the time of his testimony, described his experiences with the defendant. During a SANE interview on February 22nd of 2022, PF had testified about an incident with the defendant wherein she, quote, got really mad at him. PF described how, quote, one time I had like steak tips and I was just eating them slowly because they were hard to chew. And she got really mad at me for it because I wasn't because she thought I didn't like them and I was spoiled and stuff. And that is a quote from his SANE interview video, which is subject to protective order. For those of you asking what a SANE interview is, it is the way that they interview children. I remember we looked it up. I'm not sure what it stands for. SANE interview. Hold on, I just. And it's oddly enough, it's called the SA Intervention Network interview in Massachusetts. It's a forensic interview of a child who may have been abused. I don't know why they were using a SANE interview in this case, or if that's just the generic term that they use when because they're specially trained to interview children, and maybe they didn't have anybody at the police department that was qualified to do that. During trial testimony on May 28th of 2024, PF was questioned by the prosecution about this same incident. Prior to that testimony, Attorney Yuriy expressed his concerns about this line of questioning a sidebar, stating that, quote, oh, and see, this is why they needed the sidebars transcribed, right? Because since everything was done at sidebar and no objections were in open court, they had to wait until all of these sidebars were transcribed by the 3 reporters that they had working on it before they could make these motions. So that's another reason why, there's been a little bit of a delay here in making these motions, because they had to wait for all of these to be transcribed. So at sidebar, Yuriy said that there was testimony in the grand jury about my client supposedly getting mad at PF for eating his steak too slowly. We provided a video of that incident to the prosecution, which belies that testimony. So that was the sidebar transcript from May 28th. Attorney Yuriy was expressing his concern that PF's trial testimony would diverge from the grand jury testimony as a direct result of the defense production of pure impeachment material to the prosecution on May 6th of 2024. That is, of course, exactly what happened mere minutes later. PF was asked by the prosecution about instances where he was, quote, yelled at by the defendant. He recounted, one time we got takeout food and I was talking, one time we got takeout food and I was taking a little while to eat it and the defendant thought I didn't appreciate it, so she got mad at me. And that is what he said on the stand on May 28th. 2 weeks prior to his testimony at trial, the defense turned over a video depicting PF eating steak tips, interacting with Ms. Reed in a playful manner, wherein she never gets mad, directly contradicting his same interview from February 2022. PF undoubtedly met with the prosecution in preparation for his testimony. This resulted in PF changing his story to claim that it was takeout food and not steak tips that he had been eating, so that he could now claim that the defense impeachment video does not depict the incident be initially revealed. This is therefore another example of the prosecution using impeachment evidence produced by the defense pretrial to coach witnesses to change their testimony during trial. This unfair use of impeachment evidence creates an undue burden upon the defendant and should not be permitted. Getting the kids to lie, says Spoken TC. I'm just going to go to the chat for a minute because there's a lot of chats here, a lot of new members. Let's just say hello. Hi, Michelle. Thanks for becoming a new member. On top, thank you for your super sticker. Tracy Walker gifted 20 memberships. Tracy gifted like 90 memberships the other day. So welcome to all of the new members who have been randomly selected by YouTube to be gifted. And thank you so much, Tracy. Again, you're crazy. You're spoiling me. Karen, did I hear correctly that Mark is pro bono? I have no knowledge of that. I don't know. I know that Robert Alessi is. Greg, thank you. Says, man, Proctor is dumber than I tell people. Well, just wait for it. Wait for it. Live, laugh, toaster bath. Let's get some sharks with freaking laser beams. We got this. We got this. Thanks for your super chat. Coco De Novo, how long before the McAlbertson crew start turning each other in? The clock is ticking and their ship is sinking. I don't know. Thank you for the super chat. Uncivil, thank you for the 5 for the happy birthday. Thank you so much. I'm just a girl in the world. Thank you for the happy birthday 10 spot. I appreciate you. SB is gifting 5 memberships. Welcome, welcome, and thank you so much. Ghost of John O'Keefe is here. Thank you so much. It's a good day for Team Read. Yes, it is. It is. Thank you. I appreciate you so much. And then Tracy gifted another 20 memberships. Okay, that's like 40 already. Thank you, Tracy. Thank you, everyone who was gifted. Thanks, Book of Methodology. Thank you for the Canadian Super Chat, for tuning in. Marcia, thank you for the birthday Super Chat. Appreciate you guys so much. All right, let's keep moving here. Let us keep moving. Argument. The production of statements by adverse witnesses is not subject to mandatory disclosure under Rule 14 and must be sought by motion. And then he goes through Massachusetts Rule 14, and it says that there are certain things that are automatically disclosed and certain things do not need to be automatically disclosed. And it says Rule 14A2 allows for the defense and the Commonwealth, following production of discovery required by Rule 14, to move for discovery or other material and relevant evidence not required by subdivision A1. A distinct line has been drawn under Rule 14 between materials subject to automatic discovery and material discoverable only by motion, citing a case from 2006 which says automatic discovery does not extend to statements that the defense intends to use for purposes of cross-examination. In a given matter, the prosecution and defense are only required to produce statements intended to be used at trial, which are attributable to their own witnesses, subject to Rule 14. Statements attributable to adverse witnesses, e.g., statements attributable to a prosecution witness that the defense intends to introduce at trial, are not subject to Rule 14, but instead can be ordered produced by the judge in response to a motion under Rule 14. So they're saying we shouldn't have to automatically give it to them. If they want it, they need to make a motion. They seem to have dissected Rule 14A2 and 14A1, and then go on to say a trial judge has broad discretion with respect to motions for production of non-automatic discovery subject to Rule 14. A judge has discretion to deny a movement's motion for discovery, for discretionary discovery materials when the movement fails to establish a threshold showing that the material he or she seeks is relevant. Here, the Commonwealth's request for production of statements of individuals that they intend to call at trial was not information subject to the automatic disclosure requirement of Rule 14. Thus, production of such statements was subject to the court's discretion based on a showing of the relevant nature of such evidence and the aims of fair disclosure for trial. Number 2. The production of impeachment evidence prior to witness testimony has created unfair prejudice to the defense and has undermined Ms. Reed's right to confrontation. Rule 14C1 of the Massachusetts Rules of Criminal Procedure is the mechanism for sanctions in response to violations of discovery orders pursuant to automatic or discretionary production orders discussed in Rule 14A. Sanctions may be imposed upon non-complying parties to remediate the violation in a way the court sees fit. Sanford describes the two tenets of sanctions under Rule 14C1. First, sanctions are remedial in nature. Second, sanctions should be tailored appropriately to cure any prejudice resulting from a party's noncompliance and to ensure a fair trial. Similarly, when a sequestration order is in place with respect to witnesses at trial is violated, the judge has discretion to remediate the violation, including to admit or exclude the testimony of witnesses who have violated sequestration orders. Rule 14 of the Massachusetts Rule of Criminal Procedure gives the judges the discretion to alter or amend discovery orders as the interests of justice require. The defense's production of impeachment materials pursuant to the court's allowance of the Commonwealth's motion for reciprocal discovery clearly altered the trajectory of Commonwealth witness testimony. Additionally, the defense believes that violations of the sequestration order occurred during the first trial, and that's what we're talking about. That's what we're talking about. When you are scheduled to testify in a case, or when you are currently a witness on the stand and you have a day off, you are not supposed to be watching testimony. You are not supposed to be doing any outside research. You're not supposed to be having conversations with anyone about your testimony. If you are going to be called as a witness and you are awaiting to be called, you're not supposed to be watching YouTube at home. You're not supposed to be watching other people's testimony. That's what it means to be under sequestration as a witness. And they are saying clearly here, the defense believes that violations of the sequestration order occurred during the first trial. In addition to the inclusion of testimony not adduced at previous hearings, a message from one of the witnesses from the first trial demonstrates that at least one witness likely violated the sequestration order with the knowledge of the prosecution. Are you ready? Are you ready? No spoilers. On July 1st of 2024 at 5:48:21 p.m., prosecution witness Trooper Michael Proctor sent a text message to Assistant District Attorney Adam Lally that said, quote, "Yeah, I didn't watch A-hole Jackson's closing for good reason. Like all of us, the anticipation and anxiety of verdict has us all on edge." See a screenshot of Proctor's text message to Lally from July 1st of 2024, subject to protective order due to personal identifying information. Okay, what? What? I mean, July 1st was around the day that the mistrial was declared, right? And Proctor has already been confronted with his text messages in this case that were obtained by the feds. And he is stupid enough to still be texting Adam Lally, the lead trial attorney for the Commonwealth in this case, while this trial is still going on. Are you kidding me? What? Did he think that nobody was going to find? He didn't say a-hole. I did, because I blocked it out because, I don't curse on this channel, and you have kids in your room and you're watching at work with your headphones off. But really? Really? Like, did you think that just because they already got all your text messages that you were never going to be the subject of a text message dump again? It's mind-blowing to me. And if you didn't think that Lally was going to be called as a witness before with regard to maybe the inverted sallyport videos and whether he had them and whether he didn't turn them over, and well, I mean, now he's a party to text messages with Proctor. And maybe now I'm figuring out why he's sitting at the prosecution table, hunched over like the guy from Despicable Me, feeling completely emasculated and demoted to water boy and customer service rep as he second chairs, but is not really second chairing Hank Brennan, because it seems like he's sandbagging Hank Brennan and letting him make all kinds of stupid motions without affidavits and misspellings. And my name is Hank Brennan. GOOOO. Is that it? Is that GOOOO? Is GOOOO the one with like the hunchback? Yeah, Despicable Me. It's GOOOO, right? I mean, that's what I'm thinking of. That's what it reminds me of. Not to say that he's got bad posture, but that's the way he's looking sitting at that table. And here they are on July 1st, as if they're Teflon. This is a guy who's been suspended without pay since the summer, since right after this trial ended, because of his behavior during this trial and his text messages and other things, his lack of investigation during the murder investigation of John O'Keefe. He is now undergoing, he just the other day underwent day 2 of his Massachusetts State Police Trial Board hearing about whether or not he's going to be terminated. And now we're told they're kicking the can down to March, and there may be 1 or 2 more hearing days for him. Like, dude, was it worth your entire career, your livelihood, your family, your money, your job, your pension, your everything? What the duck are you doing? How did they get these text messages from July 1st? What else do they have? What else do they have from Lally? What else do they have from Marcy? Did this come out during the dump of text messages during the internal affairs investigation? Dude, where's my career? Exactly. Did this come out because Lally was being wiretapped and this has to do with something that was in the Marcy document dump? Like, this is wild. If you didn't think it was a problem for Proctor before, and you didn't think it could possibly get any worse for him, I mean, didn't he, during the first trial, the messages came out about what he thought about Missy and Eddie, right? And he didn't like him, and now he's calling Jackson an a-hole. And then he says to Lally, like all of us, the anticipation and anxiety of the verdict has us all on edge. All of who? You and all your friends? What, all of us? What do you mean all of us? Is there a group message between him, between Proctor and all of the McCabe's and the Alberts and Michael Morrissey and Ken Mello and Lally. And I mean, what are they doing? It wasn't bad enough when I was going to say Madam Bev Canoni. That's Madam Court. I'm conflating Madam Court Reporter and Judge Canoni. When Judge Canoni made you read your text messages on the phone and you tried to spell out, see you next Tuesday. And she's like, no, those are your words, right? And he said, yes. Well, then read them. They think they're like Teflon, like they're never going to get caught. And this, my friends, in my opinion, is just a little teeny weeny taste of what the defense has. Just a taste. Just like a little amuse-bouche, as they say in the fancy restaurants. A little palate cleanser, a little sorbet in between courses. This is like a little taste. See screenshot of Proctor's text message to Lally from July 1st, 2024, subject to protective order due to personal identifying information. Was it on Proctor's work phone? Was it on Proctor's personal phone? Was it on Lally's work phone? Was it on Lally's personal phone? I have so many questions. How did they get these messages? I have so many questions that I don't know the answers to because I don't have any inside information. Oh boy, call me Alice. This is a rabbit hole that I can't seem to get out of, and neither can you. Mr. Proctor's message. Notice how they're calling him Mr. now because he's suspended. He's no longer Trooper Proctor. Mr. Proctor's messages suggests that his decision not to watch the proceedings on July 1 of 2024. So was that the day of the closings? July 1st of 2024? I don't know. It's like a big blur. Where the F is Alice? She's right above me. She's right there. Mr. Proctor's message suggests that his decision not to watch the proceedings on July 1st of 2024 was not out of effort to abide by the sequestration order, but was instead related to the nature of the defense closing argument itself. The message implies that Mr. Proctor had been following the trial online and simply skipped the defense closing argument because he does not like Attorney Jackson. Yeah, you better keep your head down, Lally. July 1st was the day they declared the mistrial, right? That's what I thought too. So the closings were a couple of days before that. Even absent this admission, the unique nature of this case, including pervasive media coverage and real-time streaming of the in-court proceedings during trial, creates opportunity and temptation for witnesses to watch the testimony of others in violation of the sequestration order. The risk of even inadvertent witness exposure to trial testimony, such that witnesses would alter their testimony or anticipate otherwise unexpected impeachment material, would be cured by the court modifying the reciprocal discovery order to exclude defense impeachment material. Yeah. They've shown they can't be trusted in more ways than one. Apparent violations of the sequestration order allowed, coupled with the defense production of impeachment material, allowed prosecution witnesses to either, one, preempt cross-examination topics by first addressing damaging information during direct examination in an effort to take the sting out of the cross-examination, or two, to have polished answers prepared when asked about the same topics for the first time during cross-examination. The inability for the defense to be able to properly confront prosecution witnesses with impeachment material without giving those witnesses the ability to devise a way to incorporate the material into their revised testimony created an undue prejudice to the defendant and improperly controverted the intended purpose of the mutual discovery rules contemplated by Rule 14 of the Rules of Criminal Procedure. When the defense has impeachment material it intends to use at trial, the presumption should be that it is not discoverable before trial because Generally, a defendant need not reveal his defense. Quoting some cases. The defense does acknowledge that allowing the defendant to withhold evidence against a witness who is certain to be called to testify would undermine the discovery rules and allow attorneys to return to trial by ambush. Theatrics do not accord with our discovery process, citing Durham. That forceful quote, however, is in opposite to the present issue. After all, the defense is not requesting to withhold impeachment evidence until the very moment that the evidence would be sprung upon the witness on the stand. Rather, in an effort to avoid impropriety rather than create it, the defense merely requests to withhold impeachment evidence until after the witness has testified on direct examination, such that the witness cannot unfairly preempt the confrontation. Once the witness's testimony is recorded, the defense would produce the relevant impeachment evidence that they intend to use upon cross-examination to the prosecution so they can adequately prepare for redirect examination. Well, this seems pretty reasonable to me, especially if the rule doesn't require it. And they're saying, you don't even need to make the motion. We'll just give it to you. We'll give it to you after their direct testimony, because they're not allowed to prep them after they have testified. See? As a matter of procedural posture, as the court and parties are well aware, Ms. Reed is facing a retrial as a result of an initial mistrial. Nearly all of the civilian and law enforcement witnesses that will be called in this matter have already testified at least once and sometimes 3 or more times under oath, either during the state grand jury proceedings, federal grand jury proceedings, or during the first trial. The only witnesses who appear to have not testified to this point would be a small number of experts who may yet be subject to voir dire. Gives you a little taste of what's coming next. To the extent the defense sought to maintain any element of surprise, and the defense would suggest that Ms. Reed has been far more forthcoming than most criminal defendants prior to her first trial, much of that surprise has already been foiled. Please don't put any misinformation in the chat or any notifications about things that have been denied. I don't know what that's about. There is no motion to dismiss. So I don't know what Court TV is talking about either, but I can't sidetrack myself from what I'm trying to do here because I don't feel that great and my focus is already being pulled. So where were we? Okay, what the defense requests now that the court not order the defense to produce impeachment material will aid in balancing the need for reciprocal disclosure contemplated by Rule 14 with the need for remedial discovery measures to protect the defendant's right to a fair retrial. The preemption of impeachment materials by prosecution witnesses is unfair because the record clearly demonstrates that the witnesses discussed above, including PF, Lieutenant Lank, Jennifer McCabe, and Mr. Proctor, either prepare, keep Court TV out of your mouth. Either prepared for impeachment evidence prior to testifying and changed their testimony from earlier occasions or likely violated the sequestration order of this court. Oh, is that what they're talking about? They're talking about dismissing counts 1 and 3. Okay, thank you, Cop's daughter. You know, they oftentimes Court TV gets their titles completely wrong, and you think you're going to watch something that you're completely not going to watch, and it's annoying. Thank you. Hopefully that clarifies it. We went over that yesterday. That's like old news already. Right. Little cupcake. Court TV has to watch Melanie's channel to learn what's up. Yeah, we did that yesterday. Like they're a day late and $1 short on that one. My goodness. That's so funny. The defense is requesting that the court modify the order for reciprocal discovery only to the extent necessary to prevent prosecution witnesses from using pretrial production of impeachment evidence to tailor their responses, as the interests of justice require. Whether the aforementioned violations are characterized as violations of the discovery order or the sequestration order, the court is empowered to impose sanctions ahead of Ms. Reed's retrial to remediate the threat of injustice under either scheme. Scheme. I love the use of the word scheme there, because it's a scheme. And I feel really sorry for people who are behind and are trying to like speed me up to 2 times speed because I talk so fast already that it must just be like a chipmunk. Finally, the defense is not requesting the court for permission to engage in trial by ambush, nor to engage in theatrics. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is consistent with his trial testimony. A second trial, following state and federal grand juries and an extensive first trial, can hardly be called trial by ambush. Yes, correct. I agree. To the contrary, the amendments requested by the defense will permit the jury to assess for themselves the reliability of a witness's memory or whether an accuser is truthful. The defense is simply requesting a fair and equal opportunity for each party to confront adverse witnesses with impeachment evidence without each witness being able to review such material and alter their responses accordingly. Conclusion: for the above reasons, Ms. Reed respectfully requests that this honorable court allows this motion. XOXO. Alan Jackson, Elizabeth Little. All right, what document is this? I need to I have such a long list of things here that I need to check these off as we go along. David Unetti, Robert Alessi, and that was dated yesterday, February 11th. Certificate of service. Is there anything else here? No. All right, so that was 493. 493. Did that, and now here is an affidavit in support of that motion, because that's the way we do it in Massachusetts, Ms. Dianetti. David Unetti's affidavit in support, docket number 494, 494. Affidavit of counsel in support of defendant Karen Reed's motion to reconsider reciprocal discovery order. I, David Unetti, Esquire, do hereby depose and state that the following is true to the best of my knowledge and belief. It's the way it's supposed to be done. Because my name is David Unetti. I'm an attorney licensed to practice in Massachusetts since December 20th, 1989. My office address is here. I reviewed the Commonwealth's March 21st, 2024 motion for reciprocal discovery, which we read right before this one, and notice of any experts, which was allowed by this court prior to the first trial in this matter. The court ordered that the Commonwealth was entitled to discover any written or recorded statement, as well as any oral statement reduced to writing of any individual who the Commonwealth intends to call as a witness in trial, including but not limited to such statements contained in defense investigator reports or other non-legal reports. In short, the court ordered production of defense impeachment material. Oh, I need my pen. During the first trial in this matter, the defense produced impeachment material related to witnesses the Commonwealth intended to call at trial prior to their testimony in accordance with the court's order. The defense's compliance with the court's order allowed prosecution witnesses to preempt the defense's use of impeachment materials by addressing the subject matter on direct examination before the defense had a chance to confront the witnesses with the impeachment material, or on cross-examination by having answers prepared ahead of time for what would have otherwise been an unexpected confrontation. By way of example, when the defense cross-examined Jennifer McCabe on May 21st, 2024, Ms. McCabe answered an open-ended question about anything significant happening on July 30th with a lengthy and comprehensive answer about a meeting at Lieutenant Lank's house. Lieutenant Michael Lank's house. Was he the friendly that they referred to? They were waiting for a friendly. Wasn't it Lank who was the friendly? A fact to which she had never previously testified. Although the Commonwealth did not elicit this information during its direct examination, Ms. McCabe had clearly been prepared for the question on cross-examination as a result of the defense production of impeachment evidence and subsequent witness preparation with the Commonwealth. In compliance with the court's order regarding its reciprocal discovery obligations, the defense turned over location data obtained from Ms. McCabe's cell phone to the prosecution on May 6 of 2024. Another instance of prosecution witness preempting impeachment material occurred when PF testified at trial on May 28th, 2024. And again, they go over that video about the steak tips. Well, on May 28th, 2024, and that is his pseudonym, PF testified about an incident involving the defendant where she apparently, quote, got really mad at him. PF described how, quote, one time he had like steak tips and he was just eating them slowly because they were hard to chew. And Ms. Reed got really mad at him for it because he wasn't like, because she thought he didn't like them and he was spoiled and stuff. Prior to PF's questioning, I expressed my concerns about the forthcoming line of questioning at sidebar, stating there was testimony in the grand jury about my client supposedly getting mad at PF for eating his steak too slowly. The defense provided a video of that incident to the prosecution, which belies that testimony. I expressed concern that PF's trial testimony would diverge from the grand jury testimony as the direct result of the defense's production of what was otherwise pure impeachment material to the prosecution on May 6th, 2024. This is, of course, exactly what happened mere minutes later. PF testified about an instance where he was yelled at by the defendant because, as he recounted, quote, one time we got takeout food and he was taking a little while to eat it, and the defendant thought he didn't appreciate it, so she got mad at me. 2 weeks prior to PF's testimony at trial, the prosecution received a video of the incident PF described in his testimony, showing a joyful scene that stood in stark contrast with PF's characterization. I believe that the prosecution, knowing that it could no longer claim the dispute occurred over steak tips, as the video showed otherwise, advised or prepared PF to testify more vaguely about eating takeout food. I believe that the production of impeachment material prior to recording the testimony of prosecution witnesses unduly prejudiced the defendant in the first trial by allowing the witnesses to tailor their responses before being confronted with the impeachment material. For these reasons and those explored in the attached motion, I believe it is in the interests of justice for the court to allow this motion. Signed under the pains and penalties of perjury, February 11th, XOXO, David Dinetti. All right. What say you? Seems reasonable to me. Seems to me like you should be able to cross-examine a witness and be able to surprise them, because that is the entire point of cross-examination, is it not? That's what I think. Oh, thanks, Cindy, for the happy birthday. Oh, did I bite him? Yeah, I bit him. Thank you for your super chat. Happy birthday. And also Bruni Saint for your super chat. Happy birthday. Yeah, guys, I wasn't looking for super chats. I just thank you, Clinton. Yours is 129. Are your Aquarius too? Thank you for your super chat. Dr. Russell is the GOAT. DREAM. Dream Team. David Yannetti, Robert Alessi, Elizabeth Little, Alan Jackson, Mark Betterow. DREAM. Wow. That is wild. Well done. Dr. Russell is the GOAT from Norway. Thank you. Thank you, Ditto, for your super chat and for your happy birthday. Auntie Shell, thank you so much. Elle says happy Cupcake Day. Thank you so much. Jack Garnham has gifted 10 memberships. 10 memberships. Welcome to all of the 10 new members. Olivia says, my takeaway, this is direct proof that the Commonwealth has no interest in the truth. Rather, they're only motivated by getting a win or convicting Karen Reed, and will abandon truth to do so. Well, Vinnie Politan was screaming the other day on his own channel about this. He's not happy about it. Isn't this supposed to be about finding out the truth? Why does the appellate court now want to find out the truth? What's the harm in calling these people back? The prosecutors are supposed to be looking for the truth, not hiding the truth. Lori, thank you. Cannons to the right of them, cannons to the left of them, cannons before them. Happy birthday. Thank you. Thank you, Lori, for your super chat from Canada and for always watching. Thank you, Lisa. Orwellian unperson, O-N-G, the first letters of each attorney's first name spells dream. Yeah, isn't that crazy? Thank you for your super chat, Orwellian unperson, and for taking your name from Robert Alessi's motion. And Lindsay, thank you for your super chat. And Spoken TCs has gone on too long. You can't stop the corruption. Kay Willis is here with the super sticker. Thank you, Kay Willis. She sells real estate in Boston. If you need any real estate in south of Boston. Faye, it's your birthday too. Hey, Faye, happy birthday to you too. Oh, I knew I loved you here for a reason. Happy birthday to all of us today. Thank you. Thank you, Hazelnut, for your super chat. You guys are so sweet. You're too good to me. Letteros Bebedero, happy birthday to our queen. Hope you had the best day, bro. Well, I'm hanging out with you guys, of course, and all of these motions. This is like, what a great day. Charlie Blue, thank you. Oh, thank you, Susie Q, for the $50 super chat. Thank you so much. I appreciate you. Britt, happy birthday, my Aquarius sister, to you too. Happy birthday next Tuesday. Same day they were meant to be arguing for dismissal of this nightmare, but we're in the upside down. Yeah. So your birthday is the 18th? Well, it's going to be a hearing day. It's going to be a hearing day because that day is on hold right now. And we have a lot of motions to talk about because we haven't even gotten to the motion to disqualify James Crosby and the Commonwealth motion to disqualify the ARCCA experts. So we better keep moving here. We better keep moving. Oh, Nancy, thank you so much. You're very generous $100 super chat. I appreciate you so much. It's gonna make me cry. Thank you so much. All right, let's move on. Let's move on to, what number is it that I need? It's 496 that I don't have, but that's okay because I don't really think I need it. All right, let's go to 495. This is 495. Did I redline this one? Hold on. Oh, something just happened over here. Everything got all fakakata. It's happened earlier. I have too many tabs open. I think that's the problem. I mean, I need to close all these two tabs and then go back. I think I do. Oh, feet don't fail me now. All right. Well, I don't know how to do that without disconnecting this whole entire stream. So I need a tech person. Let's go to, let's see if we can find 495. Pressing the help button, it's not doing everything. Everything's kind of stuck over here. All right, you guys, just hang tight for a second. I'm going to refresh my browser and see if that helps. So just don't go anywhere. I will be right back, I promise. Well, I don't know. That really didn't seem to help. Let me see file. Finder. Let's go to Finder. Let's go to 495. Maybe I can quit the Finder and then go from there. Let's try that. Nope. Maybe I can quit this. Quit. There. Okay. Now we'll start over. I had them all open and collated, but you know, whatever. Thank you very much, Nancy S. I appreciate you. Don't worry, I will thank you all. I will thank you all. I'll get there. All right. This is docket number 495, docket number 495. And this is Karen Reed's motion to compel discovery. Now comes the defendant, blah, 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 blah. Here's all the things that we need because we have constitutional rights and we are entitled to all of these things, 5th, 6th, 14th Amendment, all this case law, statutory right to obtain evidence and things and stuff. And here's what we want under Rule 14. These are the things that we are entitled to, and this is what we want. This is going to be interesting stuff. Defense request number 1, request for all chain of custody logs, reports, evidence logs, and or other documentation regarding how the district attorney's office and or state police came into the possession of each distinct production of video surveillance footage from the Canton PD that has been provided to the defense. Dun, dun, dun. Duck around and find out. You want to start trickling out these little snippets of video in the middle of the first trial, at the end of the first trial, after the whole trial's over. Last week now, you all of a sudden got a video backing up of the Lexus into the sallyport. Here's what we want. Give us the data. Give it all to us. Where'd you get it? Who gave it to you? Who downloaded it? Where's your chain of custody log? Where's your evidence log for all of those videos that you've turned over? Per defense counsel's November 8th, 2024 email, Ms. Reed seeks discovery of all chains of custody logs, reports, evidence logs, and or other documentation regarding how the Norfolk County District Attorney's Office and or Massachusetts State Police came into the possession of each distinct production of the video surveillance footage from the Canton PD, which has been turned over to the defense in discovery. Every single one of them. This information will provide defense counsel with relevant details about when, how, and from whom the Commonwealth obtained all of the Canton PD surveillance video footage, how it was logged into evidence, and what footage exactly the Commonwealth has in its possession, and how that came to be. These details are relevant and necessary to contextualize the raw Canton PD surveillance video footage and to assess whether that video footage was subject to tampering. Attorney Brennan indicated via email on November 25th of 2024 that he would request these records, but no records responsive to this request have been produced to date. Are you surprised? Remember when Yuriy Bukhenik was questioned about it on the stand? Like, where did you get this video? When did you first see it? Who gave it to you? I don't know. I don't know. I don't know. I don't recall. I don't recall. I don't know. I don't know. I don't recall. Number 2, or B, defense request number 2, an unredacted copy of Massachusetts State Police Report number 26. In comes Sandra Birchmore. Sandra Birchmore has entered the chat, and they want it all. Here we go. Defense counsel also requested via its November 8th of 2024 email to Attorney Brennan an unredacted copy of Massachusetts State Police Report number 26 associated with the investigation into the death of Sandra Birchmore, produced in Notice of Discovery number 47. Remember, as we were going through these notices of discovery, and it was like, what is MSP number report number 26? We're starting to find out. We're starting to find out because many of the same players were involved in the Sandra Birchmore case as are involved in the Karen Reed case. And we discussed that as well. That's what that is. MSP Report 26 is relevant and must be provided in accordance with Ms. Reed's constitutional and statutory rights. The investigation into the death of Sandra Birchmore has involved many of the same material witnesses in Ms. Reed's case, including but not limited to, who's keeping track? Sergeant Michael Lenk, Daniel Whitley, Trooper Mike Dunn, Trooper Zach Clark, Colleen Crawford, Detective Calvin Albert, Lieutenant John Fanning, Trooper Garino, Lieutenant Brian Tully, Deputy District Attorney Lynn Beland, and District Attorney Michael Morrissey. That's 11. I counted 11. Given the similar allegations of misconduct by state actors in the Birchmore and Reed cases, the statements that material witnesses in Ms. Reed's case made in relation to the Birchmore investigation are relevant for impeachment and bear on the credibility of those witnesses in the instant matter. Because we know that Garino failed to find something like 34,000, 36,000 text messages on Farwell's phone between Farwell and Sandra Birchmore. Despite defense counsel's request, the Commonwealth has not yet provided the defense with MSP report number 26. In fact, Attorney Brennan replied on November 25th, 2024, that because the Sandra Birchmore case now involves a federal investigation, defense counsel should seek redacted information from the U.S. Attorney's Office. The Commonwealth has possession, custody, or control of relevant reports from the Birchmore investigation that include statements by material witnesses in the Karen Reed matter. Many of those statements have since been undermined and discredited, and consequently, they bear on the credibility of those material witnesses and are directly relevant to Ms. Reed's case. The fact that the U.S. Attorney's Office may have redacted information does not absolve the Commonwealth of their obligation to provide mandatory discovery under Rule 14. Footnote 3, which says, additionally, as explained in Section D, redacted reports omit information that is relevant to Ms. Reed's case and critical to her defense, and are thus insufficient to satisfy the Commonwealth's discovery obligations. Accordingly, this request remains outstanding. Defense request number 3. An unredacted copy of the public record response relating to all email correspondence and communications associated with the Sandra Birchmore investigation. In that same November 8th email, defense counsel requested an unredacted copy of the public record response relating to all email correspondence and communications associated with the investigation into Sandra Birchmore, produced in Notice of Discovery number 47. The Commonwealth has provided defense counsel with a copy of the response to a Public Records Act request concerning all email correspondence and communications associated with the investigation into Sandra Birchmore. However, the copy that the Commonwealth produced is the same redacted version made available to members of the public. Critically, the interest of the public in obtaining and reviewing these communications is less substantial than that of the defense. You think? The redacted version of the report omits information that is relevant to Ms. Reed's case and critical to her defense, and thus is insufficient to satisfy the Commonwealth's obligations under Massachusetts liberal discovery rules. Well, they're liberal when the Commonwealth wants stuff, not so much when the defense wants stuff, in my opinion. As described above, Attorney Brennan indicated to the defense on November 25th of 2024 that if it wants these records, it should contact the U.S. Attorney's Office seeking redacted records. For the above-mentioned reasons, including the inadequacy of redacted records for defense purposes, the aforementioned relevance of these Birchmore records to Ms. Reed's case, and the legal obligation of the Commonwealth to provide such information when it is within its possession, custody, or control, that response is insufficient to satisfy the Commonwealth's discovery obligations. No records responsive to this request have been produced to date. For those of you who are interested in it and are not familiar with the Sandra Birchmore case, or even if you are, I have an entire playlist of videos that we've done on the Sandra Birchmore case, and we went through all the Canton PD reports that we could get our hands on. And I don't know if we ever got a hold of the MSP reports, but we broke it all down a while ago, months and months ago. Defense request number 4. An unredacted copy of all reports, communications, handwritten law enforcement notes, and/or other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in this case. Also, on November 8th, 2024, Attorney Little requested, among other things, an unredacted copy of all reports, communications, handwritten law enforcement notes, and/or other documents from the investigation into the death of Sandra Birchmore, which relate to and/or reference material law enforcement witnesses in this case, which include but are not limited to Sergeant Michael Lenk, Daniel Whitley, Trooper Mike Dunn, Trooper Zach Clark, Colleen Crawford, Detective Kevin Albert, Lieutenant John Fanning, Trooper Garino, Lieutenant Brian Tully, ADA Lynn Beland, and DA Michael Morrissey. I just want to point out here that I misspoke yesterday when we were talking about Flamati. I think it was Daniel Whitley who was personal friends with Kerry Roberts, right? They live in the same neighborhood. And he was saying things about Kerry Roberts during his testimony. I stand corrected, and I wanted to correct the record. As with the defense's request for MSP report number 26, given the similar allegations of misconduct by state actors in the Birchmore and Reed cases, the statements that material witnesses in Ms. Reed's case made in relation to the Birchmore investigation are relevant for impeachment and bear on credibility of those witnesses in the instant matter. In his November 25th, 2024 email, Attorney Brennan diverged from his previous response that the defense counsel should seek materials on the Birchmore case from the U.S. attorney, stating instead that he was not in possession of these materials and referencing an ongoing defense Rule 17 motion. That reply is not responsive to the defense's request. No steak tip left behind. Well done, none your business. There is no ongoing defense Rule 17 motion regarding unredacted reports, communications, handwritten law enforcement notes, and/or other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in this case. Moreover, despite Attorney Brennan's assertion to the contrary, the Commonwealth is in constructive possession, care, and custody of these records. The reports, communications, handwritten law enforcement notes, and other documents sought concern material law enforcement witnesses in the Reed case. Those witnesses are members of the prosecution team under Massachusetts law by virtue of their participation in investigating and evaluating the Reed case, and thus their reports, communications, notes, and other documents are in the constructive possession of the Commonwealth, meaning even if you don't have them right now, you're deemed as a matter of law to have them, so you better go find them. Go get them. Therefore, the records must be produced. No records responsive to this request have been provided. And yet, well, I'm just adding this and yet part, and yet they filed their certificate of compliance, and yet they have not complied. It's pointing out the ways in which they have not complied. Defense request number 5. Request for all communications, documents, reports, memoranda, recordings of interviews, physical evidence, findings, and/or other evidence relating to the internal affairs investigation into Trooper Michael Proctor, including transcripts of the administrative proceedings. On November 8th of 2024, Defense Counsel requested the production of, among other things, all communications, documents, reports, memoranda, recording of interviews, physical evidence, and/or other evidence relating to the internal affairs investigation into Trooper Michael Proctor. Attorney Brennan has provided defense counsel with a small number of generic letters about the internal affairs investigation, as well as an internal affairs report, which states simply that Trooper Proctor has been suspended. However, the Commonwealth has yet to provide any underlying reports or documents detailing or relating to the substance of the investigation. On November 25th, 2024, Attorney Brennan replied to Attorney Little's request by asserting that he is not in possession of these materials other than the documents he has already shared, and that he doesn't believe that the Massachusetts State Police shares internal affairs investigation information because, as he understands it, it is, quote, protected under Martin, end quote. And internal affairs has entered the chat. Contrary to Attorney Brennan's suggestion, Martin does not hold directly that internal affairs information is protected and is not an absolute bar on the discovery of such materials, even under Rule 14, citing Commonwealth v. Martin, a 1998 case. It is true that although police officers generally fall within the definition of persons who have participated in investigating or evaluating the case, and either regularly report to the prosecutor's office or have done so in the case for purposes of the Rule 14, possession, custody, or control analysis, Massachusetts courts have recognized that internal affairs files, in particular, are not always in the possession, custody, or control of the Commonwealth. But the SJC has held that if a prosecutor has possession or control of the records of an investigation by an internal affairs division of a police department with respect to a particular matter, the prosecutor must review that material in response to a Rule 14 motion for the production of exculpatory facts. Accordingly, the Commonwealth has a discovery obligation to provide any communications and documents that relate to the internal affairs investigation of Trooper Proctor and that are in its possession, custody, or control. Those communications and documents are relevant given Trooper Proctor's role as the lead investigator in Ms. Reed's case before his suspension. The Commonwealth has not met this obligation to produce this evidence, and thus the defense seeks to compel its production. Defense request number 6. Request for all material and relevant communication made by, I'm sorry, let me start over because this is a good one. Hold, please. Number 6. Request for all material and relevant communications made between members of law enforcement and witnesses in this case, including but not limited to Sergeant Yuriy Bukhenik and Chris Albert, by email address and or cell phone from the inception of this case, January 29th, 2022, to the present. That's right. They want it all. From the date of death of John O'Keefe until today. And here's why. The defense is requesting all written communications between and among the Norfolk County District Attorney's Office and or its law enforcement agents on the one hand, and all witnesses in this case. On August 13th of 2024, after this trial was over, the Stoughton District Court received a police report made by Sergeant Yuriy Bukhenik regarding an incident of alleged witness intimidation. In his report, which appended a screenshot of a text message between Sergeant Bukhenik and Chris Albert, Sergeant Bukhenik describes an incident that took place on July 10th of 2024 outside Chris Albert's business. Again, July 10th of 2024 was also after the Karen Reed trial, first trial ended, and footnote number 4 says, the relevant text messages between Chris Albert and Sergeant Bukhenik were iMessages, text messages sent between Apple devices. How did they get this, you ask? Well, Bukhenik was stupid enough to attach it to a police report. Guess what that does? Opens the door, my friends. It opens the door. The door is wide open. The door has been blown open. It's like a tsunami. Sometimes you better want what you wish for. You want to selectively prosecute witness intimidation statutes, and you're stupid enough to attach a screenshot of messages between you and witnesses in the Karen Reed trial? Because what? They have you on speed dial? Was Bukhenik's personal phone? Was it his work phone? Outside D&E Pizza Shop in Canton. Sergeant Bukhenik states that he was, quote, notified by Chris Albert about an incident that Chris Albert considered to be threatening in nature. Sergeant Bukhenik noted that in the text message communications between himself and Chris Albert wrote, hey, so I just had 2 women outside my shop taking pictures, which is fine. Then one woman lifted her hand and made a gun motion to her head. I watched it and have it on video, exclamation point. Sergeant Bukhenik responded, please email it to me, and wrote, do you know who these women are? Chris Albert replied, no clue, I'll email to you. In his report, Sergeant Bukhenik also acknowledged that Chris Albert is one of the Commonwealth's witnesses in a murder case, directly referencing Commonwealth v. Reed. How many phones are having SIM cards cracked tonight? Really? Really? I remember when this happened. Somebody sent me like a screenshot from Twitter. Like there was a woman, like I don't know, like he was claiming to be threatened. This has nothing to do with the rubber ducky gate. This has nothing to do with. I think this was. I don't know who this. I don't know who this is, and I don't want to dox this person, so I have no idea who this is. But it seems to be there was a woman, two women outside taking pictures of his pizza shop. One of them went like this. He's got video of it. And now he wants Bukhenik to charge this woman with witness intimidation. Then it goes on to say, the appended text message screenshot between Sergeant Bukhenik and Chris Albert, which constitutes material and relevant evidence, is a statement from a witness in this matter, is in the possession, custody, control of the Commonwealth vis-a-vis Sergeant Bukhenik, and was improperly withheld from the defense. Yeah. Filed your certificate of compliance, didn't you? Yeah. Said you turned everything over, but oops. Forgot that stuff. Yeah, forgot about that. Kind of like Carrie Morrissey in the Alec Baldwin case, putting all that ammunition under a different file number. Look the other way, nothing to see here. It has nothing to do with the Alec Baldwin case. I made a whole new file number. That case was dismissed in open court. Sergeant Bukhenik is an investigating officer who authored the police report detailing communications with Chris Albert, has been identified as a witness in the matter at hand, and is directly involved in the prosecution's preparation of this case. Accordingly, Sergeant Bukhenik is an active member of the prosecution team under Massachusetts law. Here's a case called Beal that says the prosecution team includes law enforcement personnel working directly on the case. And Bukhenik's conduct, communications, and possession of evidence are imputed to the Commonwealth for purposes of Rule 14 discovery. Duck around. Martin is a case which says requires prosecutors to disclose evidence held by law enforcement as part of the prosecution team. The text messages from witness Chris Albert to Sergeant Bukhenik constitute statements that must be disclosed. And here's why. There's the little citation for you. Text messages may also contain material exculpatory evidence that warrants production. Footnote 5. A prosecutor is expected to actively seek out any exculpatory evidence held by the Commonwealth or another member of the prosecution team, citing Graham. Graham is one of Judge Cannoni's favorite cases, because remember how she would question Liza Little in pretrial proceedings. What about McFarland and Graham? How does this relate to McFarland and Graham? Under McFarland and Graham, this obligation to disclose exculpatory material is just that, an obligation, not a decision. Obligation, not a decision. The nature of the July 10th, 2024 exchange implies an ongoing line of communication that necessitates the need for all relevant communications via phone and email between Sergeant Bukhenik and Chris Albert since the inception of this case. The informal tone and casual language of the text messages between Sergeant Bukhenik and Chris Albert strongly suggest a pre-existing relationship and coordination. This inference is supported by Sergeant Bukhenik's police report, in which he refers to being, quote, notified by Albert about the July 10th, 2024 incident and requests video evidence. The willingness of Chris Albert and Sergeant Bukhenik to discuss material information pertaining to Ms. Reed's case via text, as evidenced by the July 10th, 2024 exchange, suggests that other text messages between the two, from the inception of this trial until the present, may also contain relevant, material, and potentially exculpatory information that must be produced. The prosecution cannot avoid its discovery obligations by claiming that the communications are covered by the work product doctrine or were conducted on personal devices or outside of formal channels. Footnote number 6. We'll talk about the work product doctrine in a second. Give me 1 second. Talk amongst yourselves for 1 second. The work product doctrine, as referenced in Massachusetts Rule of Criminal Procedure 14, exempts from discovery only those materials reflecting the legal research, opinions, theories, or conclusions of the adverse party or his attorney and legal staff. The doctrine exists to protect the mental processes and strategies of the prosecutor, not factual communications between law enforcement and witnesses. The doctrine encompasses prosecutors' notes made in preparation for trial, including notes from interviews with witnesses. Then they go on to say, the text messages between Sergeant Bukhenik and Chris Albert are factual in nature and do not contain any protected legal theories, strategies, or opinions. The communications appended to Sergeant Bukhenik's police report consist of Chris Albert notifying Sergeant Bukhenik of an incident, describing the actions of 2 women, and sharing video evidence. These exchanges are plainly factual and do not fall within the scope of the work product exception. I have to agree. Footnote 7 says, whether Sergeant Bukhenik used his personal or work cell phone email address to communicate with Chris Albert does not exempt the communications from disclosure. Massachusetts law clearly establishes that communications related to official business, even if conducted on personal devices or accounts, remain subject to public records laws and discovery. The text messages between Sergeant Bukhenik and Chris Albert directly pertain to Sergeant Bukhenik's official duties as an MSP officer investigating allegations of witness intimidation. These communications were included in Bukhenik's police report, shockingly enough, further confirming their relevance to the investigation and their status as official records. The inclusion of such material in a police report underscores its evidentiary value and negates any claim that it falls outside the Commonwealth's discovery obligation due to the work product exception. I mean, at what point do they cry uncle? At what point do they cry uncle? They're entitled to all this stuff. Bang, bang. Bang, bang is right. Regardless of whether these communications are subject to mandatory discovery as statements under Rule 14 or as containing facts of an exculpatory nature under Rule 14, prosecutors are obligated under Rule 14 to disclose any material and relevant evidence within their possession, custody, or control upon request. Here, Ms. Reed expressly requests. It's like, upon request here, now we're going to actually request it respectfully that all material and relevant communications between law enforcement and civilian witnesses in this case, including Sergeant Yuriy Bukhenik and Chris Albert, made by email and or cell phone from the inception of this case to the present be disclosed in full compliance with Rule 14 and under Brady. Okay? All of them, not just Chris Albert and Bukhenik. No. No. Any law enforcement and any civilian witnesses, any communications between Proctor and Jennifer McCabe, Lank and Jennifer McCabe, Bukhenik and Jennifer McCabe, Proctor and Brian Albert, Bukhenik and Brian Albert, Lank and Brian Albert, Tully and Brian Albert, and the list will go on and on. Bukhenik and Matt McCabe, Proctor and Matt McCabe. I can't even do the math on how many iterations of text messages that could be. Any law enforcement involved in the investigation of this case and any civilian witness in this case. That's a hell of a lot of communications if they exist. Any communications between Michael Morrissey and Jennifer McCabe. Remember, Jennifer McCabe texted something when Chris Albert did not get his restraining order against Aidan Carney and said, I know it's late, but I'm really mad that Chris didn't get it. She texted that to somebody, and Michael Morrissey attached it in an email that he sent from his private email server to a lot of judges in Stoughton about how it was outrageous that Jennifer McCabe could no longer trust the clerk of the court in Stoughton. I think it was Stoughton. I think she said she was horrified, yeah. Horrified. Crazy, right? Tick, tick, boom. Not just, this is just a little taste, a little something. But we're not done. But wait, there's more. Number 7. Copies of all notes and correspondence regarding any testing conducted in this case, along with all research and materials relied upon by the Commonwealth's experts in completing their analyses, regardless of whether the witness will be testifying to the information at trial. The defense is also seeking copies of any and all testing conducted by experts in this case, along with all research and materials relied upon by the Commonwealth's experts in completing their analyses, regardless of whether the witnesses will be testifying to the information at trial. Defense request number 8. Provide all communications between members of the Norfolk County District Attorney's Office and or its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case, including dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and list of materials received. And that sort of speaks for itself. So any communications between anybody working at the DA's office or any law enforcement personnel and any experts, and it sort of just repeats itself. Defense request number 9. All written communications, including emails and text messages between any member of the Norfolk County DA's office and or its law enforcement agents and any expert witnesses, the Commonwealth intends to call a trial. So then they want the written communications. Same way. First one was all communications, whether written or not. This information is necessary in order for counsel to be able to properly prepare for the cross-examination of these expert witnesses, regardless of whether these communications are subject to mandatory discovery as statements or containing facts of an exculpatory nature under Rule 14. Prosecutors are obligated under Rule 14 to disclose any material and relevant evidence within their possession, custody, or control upon request. Defense request number 10, a legible copy of Norfolk District Attorney's Office Bates stamp number 2390 to 2395. The Commonwealth produced a series of text messages in those Bates stamped numbers, which are completely illegible. Completely illegible. The defense requests that the Commonwealth immediately produce a legible copy of these communications. Really? Well, we're going to give it to you, but you won't be able to read it. Here you go. It's like kind of like they don't proofread, and they also don't check to see that their exhibits are legible. I wonder what those text messages are about. Hold on a second. Okay. Don't know who those text messages are from or to. Conclusion, the requested discovery is relevant within the custody or control of the government or its agents, essential for preparation. Massachusetts has a liberal standard for what is considered relevant evidence. Here's all the reasons why. Production of the requested evidence will not be unduly burdensome or inconvenient, and all of these materials are within your custody and control, and therefore, XOXO, you should grant this motion to compel discovery. XOXO, Alan Jackson, Elizabeth Little, David Yannetti, Robert Lissy. All right, so we did that. That was 495. 495. So that motion to compel, 495 was for Birchmore stuff. Yuriy Bukhenik and Chris Albert text messages, and also messages between all law enforcement and anybody who works for the DA's office. So there's that. And you wonder why they need to keep adding members to the defense team, because divide and conquer, my friends, divide and conquer. What am I doing? There's a lot of work to do, and they got to split it up, and everybody's got their strengths, and there's a lot of work, and they need a whole entire, it takes a village, it takes a team, it takes an army. It takes an army. We have a lot more to get through, but we have a lot of super chats. So let's do some of these right now. Thank you, Persephone's Pomegranate. Bring on the Dream Chain Justice Leagues. Thank you so much. Happy Lasers, FAFO, for Karen. Thank you so much for your super chat. Mike B from the 413. Liza is that quiet little ninja. She waits and then smashes. Hope she writes the defense rebuttal to Hank's ARCCA motion. The feds won't tell me what they're looking for, and gave ARCCA motion. Yeah, we're going to get to that one. We're going to get to that one. Thanks, Mike, for your super chat. Mag in Florida says, CW, how does it feel to want? Thank you so much for your super chat. True crime junkie, the OG, is having back surgery tomorrow. Wishing you all the healing vibes. All the healing vibes. True crime junkie, the OG. Wine Yogi, thanks. Saying by myself a matcha. Thank you so much for your super chat. Joan became a new member. Thank you. Mike B from the 413. Impeachment discovery equals cheat sheets for them. I know. It's like, why should you have to? Okay, you guys want to know what soup I want? I want Greek soup. How about lemon chicken soup? Soup is good. Or matzo ball soup. That's how my kids communicate with me. They're like, just say it on YouTube. You don't have to text us back. Say it on YouTube. Matzo ball soup or lemon chicken soup from the Greek place would be good. Either one. See, the thing is that when my birthday falls so close to Valentine's Day, it's like you don't really want to go out because like everybody's crowded, because there's people that go out for Valentine's Day. I don't need to go out. Plus, we got all the snow. It's a snow day today here. Impeachment is, yes. And why should they have a cheat sheet? They shouldn't. And why should they be able to prepare for things that are supposed to be a surprise on the stand that we all want to see? The surprise, right? The shock and horror of it all. You can't take that away from us. Don't take away the shock and horror of it all. Mathis says, my oral arguments were today, and I'm happy. I didn't see it. I didn't have time to watch it. So many bombs went off this morning here. All this stuff happened. So I'm going to try and go back and watch that later. Thank you, Mathis, for your super chat. That's the Kowalski case. Tracy gifted another 10 memberships. Really? Oh my gosh, you're so sweet. Thank you. Thank you so very much for your incredible generosity today. Tracy Walker was coming in here yesterday, and she's gifting memberships like a banshee. Crazy. So everyone living in the Commonwealth must give to Hank. Yeah, pretty much, Mag. Super chat. Quintessence, it's your husband's birthday today too. Oh, he's an Aquarius too. Happy birthday to your husband, Quintessence. Thank you so much for your super chat. Don't strain your credulity too much, okay? It's not my credulity that is strained. Thank you. Well, I am. It is strained. This is insane. Kimmy said, Colleen Prescott married to Bev's brother, sitting cozy on a couch with Caitlin Albert. Wouldn't that be considered a conflict? Happy birthday. Thank you. Somebody sent me some of that stuff like that's floating around on Twitter. I can't like verify it, so I don't really know. But it seems that word on the street is that there are some pictures floating around out there that may or may not be Judge Cannoni's sister-in-law, a woman who is married to Judge Cannoni's brother, who tragically passed away this summer after the trial ended. His wife in a photograph with her daughter and Caitlin Albert from many years ago. I don't know if it's real, but that's what you're referring to. So thanks for the super chat. Fair Raven, oh, you're a sweetheart. Thank you for tuning in from Ireland and for your super chat. Little Misfit for days, buyer and friend and courtesy right now. We're standing our against guys talking to our house of no more skirting tires or threatening Gmail. Who needs a restraining order? Thank you, Little Misfit, for your super chat, but I'm confused. Fairy Raven gifted a membership. Thank you. Marissa has been with me for 5 months. Thanks, Marissa. Dove's House, please help me understand. During this first trial, were the sallyport videos and the key cycle spreadsheets real evidence or demonstrative exhibits? Well, if they were demonstrative exhibits, they would be entered into evidence. So I don't know that they were authenticated, but they were entered into evidence. They were marked as evidence and they were entered in. That's my understanding of it. Anything that's shown to the jury is evidence. I mean, it would have to be approved before it was shown to the jury. So yes. On top, thank you for your super sticker and thanks for the super chat. Dove. Hank's Nightmares through reality. Thank you for your super sticker. Thank you, Crisco. Angel from Australia, tuning in from down under, not in Chattel. I want to say happy birthday. Thank you so much. Oh, thank you so much. Thank you. I appreciate that so much, Angel. Lori Lake, a temporary LOA to assist in this matter will only be approved with cupcake updates. Thank you, Lori, very much for your super chat. Thank you, Magnolia Gypsy. Love you. Robin, thank you so much. So they're not supposed to watch anything even after they testify. Not if they're subject to recall. So if they're subject to recall, no, they're not supposed to watch anything after they testify. Because there is always a chance that the defense could call them in their case in chief as well. So it depends. The answer is it depends. Thank you, Robin. Craig, did you see Turtle Boy's report that there's proof that the Commonwealth coached a lie out of John's 11-year-old nephew on the stand? No, I did not. Coached him to change his testimony after it was proven false? No, I did not. But I think that is what they're referring to in that motion that we just read, right? That he testified one way during the interview that was given shortly after John O'Keefe's death. And then he testified a different way on the stand because of the video that Karen took, or a video that someone had of him. So I'm assuming that's what you're referring to. I didn't see it. Closings were June 25th. Thank you, Seuss. Thank you for your super chat. Jen says, Melanie literally says, everything we think and feel. God, I love it here amongst my people. Thank you, Jen, for your super chat. Thank you, Hank's Nightmares, for your super chat and birthday wishes. And Laura Williams, if a mistrial is called, can Karen still sue to get money back? Love from the Netherlands. Happy birthday. Oh, you're Feral Aquarius too, February 8th. If a mistrial is called, well, they would have to see, there would have to be final resolution to all of this, I think. So if a mistrial is called again, and they choose not to prosecute her, then yes, she can start her lawsuits. If a mistrial is called again and they choose to re-persecute her, needs to kind of wait until there's a finality to all of this. Thank you for watching from the Netherlands. Lori, good thing you were born. I'd be losing my mind right now. Thank you, Lori, for your super chat. Kokomo, Indiana became a member. Thank you so much. Thank you, Dina Jam. You guys are amazing. Thank you, Bernie Heaven. Thanks, Gail, for becoming a member. Aries Girl, thank you for appreciating me and my wicked smart insights. You guys are awesome. Yep. Orwellian Unperson says, wait, it was Officer John O'Keefe who didn't want Karen Reed spoiling the kids. Right. We learned some of that in the text messages too. Not today, but in prior days. Thank you. Things just got better. Oh, all right. You're getting up there for name of the day. Well done. Thank you. It's hash value, not hashtag. Oh, you're up there too. Thank you so much for your very generous $50 super chat. Wants to know if there are steak tips on the menu. I don't think so. I think today's a soup day. Today is a soup day. There's a lot of snow outside. No school. Icy. And thank you so very much for your very generous greetings and super chattings. Chopped trials. Let's not forget, Lally said a Karen's arraignment on 2/2/22. She said, I hit him. Not in a report anywhere. Testify, Lally. Well done. Thank you for your super chat. Aussie Steve, who's tuning in from Australia. If we weren't outraged already at the persecution of Karen, now we have evidence they endured a trial to lie. How low are these people? Thank you, Steve, for tuning in from Australia and for your super chat. And Decline for your super chat. I'm listening while at work, not watching. Thank you, Decline. Thank you if you're listening. Happy birthday from the Taint Team 6, says Carrie B. Thank you, Carrie. Thank you, Donna, Nealon. Thank you so very much. And the ghost of John O'Keefe with another big super chat, $50. Thank you. I think the defense tried to play nice last trial, but now they know that the Commonwealth has no desire to seek justice, only to convict an innocent woman, obtain a win while covering for the McAlbert. You know, I think they're mad. I think they are mad. They're mad as hell, and they're not going to take it anymore. They are mad as hell, and they're not going to take it anymore. Name that movie. I know you know. I'm mad as hell, and I'm not going to take it anymore. It's an oldie but goodie. Thank you, Ghost of John O'Keefe. You're so awesome. Oh, I see some people going to Block Island today. Oh, so sad. Tammy Walker. I wouldn't stop there. I would ask for all logs and evidence. Lots of all the prosecution's evidence. Yep. Thank you. And thank you, Barbara Dulong, for your super chat. And thank you, Janice Donovan, for your super chat and your birthday wishes. Dove's House, did you just ask this or did I? Yeah. Real evidence, demonstrative evidence. Yeah, I think I said did not yet delete that one. Christy Painter's daughter says, already doing shady stuff, sneaky weather, Lally or Breenan. Ugh. Thanks, Christy. Christina became a member. Tara became a member. You guys are awesome. You better, you bet. Yeah, maybe we better put that on the playlist, Namasus. Thank you. Find another one. Oh, you said La Misfit, daughter, not. Okay. Gotcha. All right. Moving on. We got a lot of things to cover. Let's go to 490. 490. That's where the lasers is going to come in. So we've got 490, 491, and 492. Well, they're bringing lasers in. All right, 90, 91, and 92. Gonna do a little reconstruction of what happened on the ring footage in the driveway of One Meadows between Karen's car and the Traverse that belonged to John O'Keefe. Docket number 490. This is docket number 490. 490 coming in hot. I didn't redline this one yet. I may not even do it as we go along because I'm getting tired. Okay. Defendant's rules 14 and 17 motion. Oh, look, I did it already. For a court order authorizing defense access to the Lexus and Traverse and to the driveway at One Meadows Avenue in Canton to conduct independent testing and analysis. So there's that. No way. Not even true. That can't be true. Really, Jamie Birch? Is that true? I know a lot of people want to hear about Karen Reed today, I guess. I love Emily, so no shade to Emily. Look, I got Dave Matthews posters. I think we'd be great friends if we ever got to meet each other. I just want to point out that I do believe that Mrs. O'Keefe, meaning John's mother, is living at One Meadows now with the children, I think. So I think they live at One Meadows, and so the defense wants access to the driveway there. going to have to go through them, I guess, I think. If they still live there, I don't really know. But so here's what they want. Pursuant to Rule 14 and Rule 17. Moving this honorable court to grant the defense access to the 2021 Lexus LX 570, that's Karen's car, as well as to the 2019 Chevy Traverse, Chevrolet, for independent examination and testing by defense expert witness Robert O'Neill, Jr., MS, ME. It's a new witness, a new expert, Robert O'Neill. Ms. Reed requests that this order, that Mr. O'Neill be given brief access to the collision incident locus, which is the driveway at 1 Meadows Avenue in Canton, to collect necessary photographs, measurements, and scans of the area. He's going to get in there. He's going to scan it. He's going to do it. He's going to bring his laser beams, and he's going to get it done, if the judge says so. And then footnote 1 says our expert estimates that this examination would take approximately 2 hours. They want to prove that the collision between Karen Reed's Lexus backing out of the garage at 1 Meadows on the morning of January 29th of 22 at approximately, I don't know, 5 a.m. or a little bit after 5 a.m. That was captured on Ring video, where it seems that she comes into contact with John's car in that driveway. They want to have an expert reconstruct that accident to say that could have caused her to crack her taillight. In my opinion, that's what they're trying to do. As grounds for this motion, Ms. Reed states that these vehicles are currently and have been in the exclusive control of the Commonwealth. Justice requires that the defense have equitable access to these vehicles to create an independent scientific reconstruction of the collision. Further, Ms. Reed requests that this court issue a court order and subpoena for additional daytime footage from the home security camera. Huh. So is there more footage from the home security camera? Hang on. I guess I didn't read this very thoroughly the first time. That additional security footage will allow the defense to analyze the quality of the recordings that this camera captures more thoroughly and to compare the daytime footage with the existing dark, snowy footage of the collision. Mr. O'Neill also seeks brief access to Mr. O'Keefe's driveway in order to visualize the incident location, take measurements, and/or conduct scans of the area. This access will contribute to an accurate reconstruction of the collision incident and would help satisfy Ms. Reed's constitutional right to present all the necessary evidence in her defense. Factual background, here's what she's charged with. The court understands that any evidence of a collision between the Lexus and the Chevy during the morning of January 29th will be crucial to reconstructing exactly what happened to Mr. O'Keefe. The Commonwealth, via the Mass State Police, conducted multiple rounds of vehicle testing, processing, analysis, and collision reconstruction without informing the defense of their plans to do so. On February 3rd of 2022, Massachusetts State Police were given access to the driveway at 1 Meadows Avenue, in order to complete forensic tests and photograph the scene. After the Commonwealth took possession of the vehicles, they conducted multiple further accident reconstruction and analyses, including as recently as July 24th, 2024, after the trial. Inexplicably, the Massachusetts State Police conducted some of these tests in the presence of the decedent's brother, Paul O'Keefe. What? I didn't see this the first time. And his friend Brendan Kane. Wait, isn't Brendan Kane the guy who's been on like every single documentary? We're gonna need a bigger boat. Brendan Kane has been on every single documentary, 2020, whatever, everything, as John O'Keefe's childhood friend, right? Is that the guy? I'm gonna read that again. Inexplicably, the Massachusetts State Police conducted some of these tests in the presence of the decedent's brother, Paul O'Keefe, and his friend, Brendan Kane, both of whom were civilians. These tests were completed without alerting the defense and solely according to the Commonwealth and State Police's timelines. Yeah, the crazy just keeps coming. The crazy just keeps coming. I mean, what the duck? July 24th, 2024, after the trial. Before Brennan got involved. He was involved in July, right? I mean, right. Somebody said, I guess it didn't go the way they planned, because if they did this on February 3rd of 2022, they were doing testing in in the driveway of One Meadows. They never used any of that in the first trial. I mean, we know that Trooper Paul did some testing of the Lexus at the Canton Sallyport, where he was gunning in reverse. There's video of that. He was doing some testing about the braking system and the backup camera and stuff like that, and things and stuff. But didn't know that they went over to One Meadows and they did some stuff there, because I don't think any of that came in at the first trial, right? You guys know? Yeah, that's when Trooper Paul submitted his supplemental report, right? Yeah. Trooper Paul was still around. Yeah, didn't they exchange a supplemental report that was done around this date? I think so. Argument: the defense has a constitutional and statutory right of access to the vehicles, the security camera footage, and the collision location. Ms. Reed requests access to the Lexus, the Chevrolet, the daytime security footage, and the collision location. The defense has a right to access and independently test this relevant and material physical evidence, and they do. Here's Graham. Ms. Reed's right of access to this evidence is just that, a right, not a matter of discretion. I'm going to skip around a little bit. I'll slow roll it, so in case you want to freeze frame and go back to it later, you can do that. And they go through all the case law and why she should be allowed to do this. Denial of Ms. Reed's right to access and examine this evidence would therefore be an infringement of her due process rights on the U.S. Constitution. Same thing under the Massachusetts Declaration of Rights. Fundamental fairness. She has the right to a fair trial. She has to have access to the Commonwealth's physical evidence for independent testing. And also, according to the Massachusetts Rule of Criminal Procedure, her rights are also protected. Prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects. Citing some more case law. The two vehicles, daytime security footage, and driveway are all material and relevant evidence that is critical for Ms. Reed's defense. Ms. Reed is entitled to fair and independent access to this evidence under the U.S. Constitution, Massachusetts Constitution, and the Massachusetts Rules of Criminal Procedure. The Commonwealth claims that pieces of the right taillight of Ms. Reed's Lexus broke off and were left at 34 Fairview Road on the night of Mr. O'Keefe's death. Security camera footage from One Meadows Avenue shows the back of Ms. Reed's Lexus colliding with the parked Chevy early in the morning of January 29, 2022. Whether the Lexus taillight was broken in that collision is crucial evidence and material to Ms. Reed's defense. Ms. Reed has a fundamental right to access these vehicles, daytime security footage from that same home security camera, and the location of the collision in order to conduct independent forensic testing. Further, in light of the state police unexplained choice to have the decedent's brother and friend, both civilians, present during official forensics testing, Ms. Reed respectfully requests that any members of the Commonwealth's team, and especially the O'Keefe family, not be permitted within 200 feet of the vehicles while the defense expert, Mr. O'Neill, conducts his testing analysis. Well. You can never tell. Ms. Reed understands that it may not be possible to conduct a fully independent testing because the vehicles are in the custody of the Commonwealth, but fairness requires that this analysis be kept private from those who might want to prematurely glean insight from our findings, right? Because there may be some curtain twitchers inside the house, or maybe some curtain twitchers will go next door and look out their curtains and videotape what's going on out there. Regarding access to the traverse and the driveway at 1 Meadows Avenue, the defense has met the requirements of Rule 17. Here are the 4 criteria that must be met. We've been over these many, many times. We don't need to do it again. Under Dwyer, I'll leave it here in case you want to look at it. Need an affidavit. You need to look through the protocol. You need to look at the criteria. David Yannetti gives an affidavit and meets all the criteria. Conclusion. For the foregoing reasons and in the interest of fairness, Ms. Reed respectfully requests that this honorable court grant her motion in limine for access to the above-mentioned vehicles, the home security camera footage, and the locus of the collision incident. And that is number 490. And then from there, we move on to 491. This is an affidavit of the expert, Robert O'Neill. Because that's what you do when you make motions. You attach affidavits of experts and people with knowledge. Affidavit of Robert O'Neill in support of defendant's Rule 14 and 17 motion for all of the things that we just talked about. I am an ACTAR, ACTAR, accredited accident reconstructionist. I'm employed at, I'm not going to pronounce, AZYX, AZYX Incorporated, an engineering consulting firm that specializes in accident reconstruction and video analysis. I've been working in this capacity at AZYX, Axis, I don't know, AXYZ, Axis, I don't know, for approximately 29 years. I was asked to consult with the defense regarding the above captioned matter to investigate and review the ring camera footage that depicts the interaction that took place between the Lexus and the Chevy Traverse in the driveway of 1 Meadows Avenue in Canton. To perform this video analysis, I will need to have 3D measurements for the site where the incident occurred without snow being present. I can perform this analysis using the laser scan data collected previously by Aperture. Oh, they already took laser scans. Alternatively, Access personnel would need to enter the driveway of 1 Meadows Avenue in Canton at a time when there's no snow covering the driveway or appurtenances and the surfaces are dry. We would set up a 3D scanner in multiple locations on the driveway. We may also need to take measurements separate and apart from the 3D scanner, along with photographs and video of the site. I estimate the investigation and work in the driveway would take approximately 2 hours. To conduct an accident reconstruction regarding this matter, I will need 3D measurement data and photographs for the exterior of both vehicles. I can perform the initial alignment analysis with the laser scan data and photographs collected previously by Aperture. Alternatively, Access personnel will need to perform a 3D scan of the exterior of both vehicles. We may also need to take measurements separate and apart from the 3D scanner, along with photographs and video of the site. To recreate the circumstances that existed on January 29th, 2022, I may need to fill the tires of one or both of the vehicles with air. Assuming that the vehicles are located on a flat surface in the same place, with a minimum of 15 feet clear around each vehicle, and while both vehicles are dry, I estimate that my investigation and data capture would take approximately 2 hours. So they're not really asking for too much. XOXO, Robert O'Neill, new expert witness. And then here, it's an affidavit of David Yannetti. That was 491. This is 492. David Yannetti's affidavit. Here's all the things and stuff that we're going to need. And he says, the Commonwealth has provided notice to the defense that it has retained an expert to examine and performed, that it has retained an expert. Did he already examine? Who examined and performed tests related to my client's Lexus and Mr. O'Keefe's Traverse. The defense desires the same opportunity to have an expert conduct independent testing. The Commonwealth has also provided notice to the defense that it has retained an expert to examine and conduct tests in the driveway of 1 Meadows Avenue in Canton. The defense desires the same opportunity to have an expert conduct independent testing. All right. Well, what's good enough for the goose? Good enough for the gander or the duck. What the duck? The defense should have the same opportunity to conduct testing that the Commonwealth has. It should not matter that one of the vehicles in the driveway in question are not in the Commonwealth's custody. This motion is therefore brought in part pursuant to Massachusetts Rule 17. The Lexus and the Traverse, as well as the driveway at One Meadows, contain information that's both evidentiary and relevant to the issues in this case. The Commonwealth had complete access to both vehicles in order to perform testing. Both vehicles are relevant to the case. The Commonwealth alleges that the Lexus in their possession struck and killed Mr. O'Keefe, causing the Lexus rear taillight to shatter outside 34 Fairview Road in Canton. The defense denies that allegation and believes that the Lexus instead struck the Traverse in the driveway of One Meadows, causing the taillight to break there instead. Both vehicles therefore contain evidence that is relevant to both the prosecution and the defense. Only the prosecution currently has access to both vehicles. Access to the vehicles and the driveway is not otherwise procurable reasonably in advance of trial through the exercise of due diligence. The Traverse and the driveway at One Meadows are in the possession of a third party, the O'Keefe family. So I guess they still do live there. My co-counsel has requested the Commonwealth to inquire of the O'Keefe family to grant the defense access to the Traverse, while I have asked the Commonwealth to inquire of the O'Keefe family to grant the defense access to the driveway. The defense has been told to file the appropriate motion before the court in order to obtain access to either or both. So again, while every court would prefer that attorneys meet and confer and try and work things out amongst themselves instead of bothering the court with motions, Hank Brennan keeps telling them to file motions. You want the metadata? File the motion. You want the logs for the Canton Sallyport video? File a motion. You want the video that we have on some retired detective's hard drive? File a motion. The defense cannot prepare for trial without the ability to examine, inspect, and conduct testing on the vehicles and the driveway, and the failure to obtain and inspect the vehicles and the driveway will unreasonably delay the trial. The issue of how the taillight of the Lexus cracked or broke is a paramount issue at this trial. One party cannot have full access to conduct whatever testing is necessary, while the opposing party is prohibited from conducting its own testing. The denial of this motion will impair the ability of the defense to cross-examine Commonwealth witnesses and to present a full defense at trial. This issue is so important that a denial of this motion will likely necessitate an interlocutory appeal, which will further delay the upcoming trial date. So it's like, okay, you want to play? We're going to appeal it, and that will stay the case from proceeding to trial. So if you really want it to go to trial, they're entitled to it. I mean, if the Commonwealth is entitled to test these things, so is the defense. And the Commonwealth has been in exclusive custody and control of Karen's car since January 29th of 2022 when they seized it. The motion is made in good faith and is not intended as a fishing expedition. The defense is not speculating about whether the vehicles and the driveway contain relevant evidence. The Commonwealth agrees that relevant evidence will be found on the vehicles and the property, as that is why they access the vehicles and the driveway to conduct testing. In good faith, the defense needs to access the vehicles and the driveway to conduct the specific testing that needs to be done in this case. For the foregoing reasons, I would respectfully request that this honorable court allow this motion, XOXO, David Yannetti, signed February 11th, under the pains and penalties of perjury. Somebody get out there and go on Facebook Marketplace and see if that Traverse is up for sale, or if it's already been sold, or if it's no longer, if it was disposed of on a military base in a dumpster somewhere. Just keeps getting crazier and crazier. They've already done the testing, but you want to do testing? Make a motion. Okay, so that was for 90, 91, and 92. Motion for the driveway to bring the laser beams in to do the measurements. Let us now look to a Commonwealth motion to exclude the employees of ARCCA. Docket number 497. Docket number 497. Let's walk amongst yourselves for a second while I pull that up for you. There's going to be a lot of things to talk about next Tuesday. I'll see you all next Tuesday. I guess because that date's not coming off the calendar anytime soon. Coming up, docket number 497. Is that what you said you would like to see? Oh, but of course, I've got it. Got it all for you. Docket 497 is the Commonwealth's motion to exclude. Well, it's the Commonwealth's motion to exclude employees of ARCCA. 4-2. Heretofore. Now's a good time to remind everyone that there's over 6,800 people here, and we would really, really need to get those numbers up on the like button. We're not even at 50%, and that's unacceptable. Unacceptable. We can do better. You can all do better. You may need to close out the chat on your phone to hit the like button, but even if you're hate watching, hit the down like button, hit the thumbs down button, because, engagement, right? Team Brittany, I saw that go by. I'm not going to highlight it, but people wonder, why did I get timed out? Why did your moderators time me out? Because you don't do stuff like that on the internet. You just don't. Commonwealth's motion to exclude employees of ARCCA. The Commonwealth moves to exclude the defendant from calling employees of ARCCA, including but not limited to Daniel Wolfe and Andrew Rentschler, PhD, due to the defendant's failure and inability to comply with discovery obligations under Rule 14. This is the motion that they threatened to make. Now they're making it, and you may know them as the Crash Daddies. As revealed during the defendant's first trial, Dr. Wolfe and Dr. Rentschler were two experts retained by the federal government in furtherance of the U.S. Attorney's investigation of an unspecified federal crime. Both Dr. Wolfe and Dr. Rentschler admittedly did not review all pertinent and relevant evidence that exists in this case, asserted they did not speak with the defense prior to their testimonies, and conducted experimentation and analysis that exceeded the facts and the evidence in this case. They also testified they didn't need to. Nonetheless, the court permitted both Dr. Wolfe and Dr. Rentschler to testify on behalf of the defendant in June of 2024. Oh, are you going to accuse Judge Canoni of making a mistake by allowing them to testify? Mr. Brennan, this is a new trial. It's a new trial. It's a whole new day. It's a brand new world. The parameters of the experts' opinions were not provided by the defendant prior to her first trial, and portions of the experts' opinions were not expected nor properly noticed. Oh, you mean they caught that by surprise? Furthermore, during the first trial, Dr. Wolfe and Dr. Rentschler testified to reviewing information that was not known prior to rendering their opinions, and this was not previously disclosed to the Commonwealth. Reviewing information that was not known prior to rendering their opinions. Okay, well, didn't they do an entire day of like voir dire of these two kind crash daddy gentlemen? Tall drinks of water. Didn't they do like an entire day of voir dire on them? Because I do remember that. Prior to and during the defendant's first trial, the Commonwealth repeatedly moved for reciprocal discovery from the defendant. Citing a restraint and inability to comply with Rule 14, the defendant failed to provide the Commonwealth with any discovery from ARCCA, Dr. Wolfe, or Dr. Rentschler. Yeah, but here's the thing. Everything that the feds turned over to the Commonwealth, they also turned over to the defense. So the Commonwealth had everything that the defense had. The defense did not have anything extra, which makes this motion even dumber. Yes, I would agree. I would agree. Everybody got the same stuff, and it has come out that the jury was a bit confused. And in fact, the jury thought because the attorneys could not mention that they were hired by the FBI, the jury thought that they were hired by Karen's auto insurance company, weirdly enough. So I hope that maybe that's corrected in this trial. To allow the defendant ample time to retain her own experts and to prevent any delay in the April 1, 2025 trial date, on December 5th of 2024, the Commonwealth renewed its request for discovery, enumerating 13 areas of discoverable materials related to ARCCA from the defendant. Yeah, we went over that. On January 6, 2025, the Commonwealth notified the court and the defendant of its intention to move to exclude ARCCA and Dr. Wolfe and Dr. Rentschler based on the defendant's repeated failure and inability to comply with Rule 14. To date, the defendant has filed no response nor produced any additional discovery. On February 6 of 2025, Attorney Jackson indicated to the Commonwealth and this court that he intends to call experts from ARCCA, presumably Dr. Wolfe and Dr. Rentschler, at the defendant's upcoming trial. Well, I hope so. On December 4th of 2024, the Commonwealth filed a written request for discoverable material from the U.S. Attorney's Office. Two-year request. See Exhibit A, which I believe is under seal. Or impounded, as they say in Massachusetts. On January 30th, 2025, the Commonwealth and Defense Counsel received a response from the U.S. Attorney's Office citing certain federal statutes and regulations that restrict the complete discovery the Commonwealth is entitled to. See Exhibit B, which I think is also impounded. Peculiarly, despite the formal 4-page letter received on January 30th, 2025, following the party's appearance before this court, February 6, 2025, the Commonwealth and Defense received an email from the U.S. Attorney's Office stating that their contract with ARCCA ended on July 31st, 2024, and should either party wish to engage ARCCA for additional analysis, any further engagements must not infringe on any federal privileges. Rule 14 demands reciprocal and expert discovery. As the proponent of the evidence, the defendant bears the full obligations of Rule 14, which is automatic discovery. The defendant cannot shield herself from discovery obligations by citing restraints by the U.S. Attorney's Office or by now perhaps claiming to have independently retained ARCCA for additional analysis and producing only a limited portion of expert discovery. The Commonwealth remains unduly prejudiced by the defendant's delays in providing appropriate discovery and notice to the Commonwealth. The Commonwealth has diligently sought expert discovery from the defendant and U.S. Attorney's Office for approximately 10 months. Olivia's head is going to pop off. Olivia, I don't know if you're still here, but how long did it take the Commonwealth in pre-trial to turn over simple things like clothing, like, oh my God, the audacity, right? The audacity. 10 months. It's nothing. It was 3 years before they started turning over sallyport video in the middle of trial. I mean, it just turned 3 years, just January 29th. So they just turned over some video of the Lexus backing up into the sallyport 3 years later. Yeah, we can do better. We can do better. Clothing took 22 months. Thank you, Olivia. 22 months to get access to the clothing to have it tested. Yeah, 22 months. You know what else they never tested? The additional DNA contributors of the other DNA samples that were found on Officer John O'Keefe's clothing, right? Weren't there like 2 male contributors to some of the stains on John O'Keefe's, the red-brown stains on John O'Keefe's jeans and shirt? 2 other male contributors. They never tested that DNA, right? Took 9 months to turn over the Canton police report. Oh, right. And then when they did, weren't there some changes to it? Like Brian Higgins' cell phone number was changed, I think, or Brian Albert's cell phone number was changed, and there were some extra photographs, and they thought they were turning over the same police report that they turned over, but it was different. Yeah. Yeah. A second voir dire, oh, so he's admitting there was a first voir dire, is not an appropriate remedy as the defendant has continued to sidestep their discovery obligations. The Commonwealth is entitled to a fair trial. The Commonwealth is entitled to a fair trial. How many times are we going to hear that today? The Commonwealth is entitled to a fair trial. I don't know that I've ever seen that before in any other motion by the state or the prosecution. I mean, understandable. I mean, Hank Brennan is a defense attorney. He's been hired to prosecute this case, but he's typically a defense attorney. So Commonwealth is entitled to a fair trial and simply has sought what every criminal defendant in the Commonwealth of Massachusetts is obligated to produce. Well, no, because that's not exactly true, because every other criminal defendant in the Commonwealth of Massachusetts does not have the FBI investigating the investigation of the case for which they are undergoing persecution. So, there's that. There's that. So, no, not really. Not really. Because how often is it in Massachusetts that you have the FBI doing a parallel investigation into the investigation of the defendant's case investigation? Yeah, doesn't really happen ever. The Commonwealth is entitled not to repeatedly be ambushed at trial and be permitted to effectively prepare for cross-examination of any witnesses. Well, I know that you weren't involved the first time, Mr. Brennan, but it seems that perhaps there wasn't any ambush because your witnesses, and I say your witnesses because you are now the Commonwealth, your witnesses in the first trial seem to have been prepped on the impeachment material so they could kind of like head it off at the pass. Kinda. So you weren't really ambushed because you got all the impeachment material ahead of time. The Commonwealth is entitled not to repeatedly be ambushed at trial and be permitted to effectively prepare for cross-examination of any witness. Strategic decisions do not alleviate a defendant from discovery compliance. After 10 months, the only appropriate remedy is exclusion. What now? What about that video you just turned up over like a couple days ago about that Lexus backing up into the sallyport garage? That probably, according to Alan Jackson, is exculpatory and may in fact show that the taillight was completely intact. What about that? I don't know. Alan Jackson said it was exculpatory. That's the only thing I can think of. Because if it shows it backing up and it's an exterior camera, it's going to capture the rear of the vehicle backing in, right? The taillights, etc. Is it inverted? Because, I would call an inverted video. I would call introducing an inverted video at trial and ambush, especially when your GOOOO asked Yuriy Bukhenik if it was a fair and accurate representation of the way the sallyport looked on the day of the video, and he said yes, and then it wasn't until cross-examination that he said, well, yeah, it's like, it's like a mirror. It's like a mirror. It's like accurate. It's like accurate, but it's like flipped. It's like, inverted, like a mirror. It's like a mirror image. No big whoop. No big whoop. So that's what ambush is, sir, counselor. Respectfully for the Commonwealth, XOXO, Hank Brennan. So hang out. This is 497. Did I say it was 497? That's the Commonwealth's motion to exclude employees of ARCCA. 498 is the motion to impound, which was allowed. But once again, I'm not seeing that any affidavit was attached to this motion, so you know what that means, class. It's facially insufficient. That's right. Facially insufficient, defective. Sorry, you didn't include an affidavit. Oops. Well, I mean, are we learning nothing? Is every day a new day? It seems like every day is a new day. Don't go anywhere because there's more. There's more, but let's get to some questions while we're here. Tracy says, I hope Ms. Little, not me. I mean, Liza laughs every time she uses Graham. She must. She must love to cite that case. And McFarland. And she is fire on acid on paper. I'm loving it. Karaoke, thank you so much for tuning in from Canada and for your wishes and for your super chat. And be humble, fair, and kind. Thank you so very much for tuning in from the UK. And for I would never, of course, take time out of my day to share these amazing motions because you just can't make this stuff up. You just can't. And if you were sitting in a Hollywood writer's room writing the script, nobody would believe it. You wouldn't be able to sell to anybody. They'd be like, yeah, no, that's just not credible. Nobody's going to believe that. It's too far-fetched. Thank you so much for tuning in from the UK. The world is watching. The world is watching. Dream Team, change your name. Thank you so much. Thank you so much for your super chat. I appreciate you just as much, if not more, than you appreciate me. Homegrown alligator from Australia. Finally caught a live show. Mind-boggling what's going on over there. Free Karen Reed. Justice for John O'Keefe. Lives, either you live for my coverage or you love my coverage, one or the other. But thank you for tuning in. The world's watching. Hello, happy birthday. Hello, my love. Thank you so much for your super chat. Silly. Homegrown alligator became a new member. That was John Little coming in with $10. Kyle, thank you so much for your 5. I warned anything department related goes on the work phone. Oh, you were warned. I was warned. Anything department related goes on the work phone and computer. Otherwise, my entire personal life was subject to audit if I used it. Yes, I'm taking it that you're retired law enforcement. Yeah, but these guys, I mean, they should have learned that during the first trial, but they just didn't. And that's why Michael Morrissey's personal emails are discoverable. And they're being turned over in both this case and in the Aidan Carney case, because Michael Morrissey used a private email to email all of the Stoughton judges to talk about, county business. Lady Zelda is here. She reads tarot cards. And if you want to know what's going to happen next, go over to her channel. Lady Zelda Kelly, thank you so much. Happy birthday laugh for you. Spell check is my worst enema. Hashtag Hank Brennan. Thank you. Thank you, Lady Zelda Kelly. You are appreciated. Dove's House, is it true demonstrative exhibits are not given accessible to the jury during deliberations? In Massachusetts, I've covered a lot of trials since then. And it depends on the jurisdiction. And I don't, chat, remind me if the jury brings this stuff back in Massachusetts, because there are so many trials that we have covered where the jury had to come back into the courtroom and be shown things on laptops, or they had to bring a laptop in. That's a great question, Dove's House, and I just don't have the answer at the tip of my tongue. But they did ask for certain things. During the trial, they asked for the CERT report from when they started finding taillight pieces. And they were told, you have everything you need. So my guess is that they were given this stuff to bring in. And because there was no log of those taillight pieces being found, the CERT report, they were not told that it did not exist. They were just told that they have everything that they need. If I'm wrong, as always, correct me, chat. Team Brittany, thank you so much for giving 5 memberships. Not only are you an amazing human being and one of my besties, you are also an amazing moderator for this channel. One of the velvet hammers that we have here between Little Cupcake, Team Brittany, and whatever Scott's name is today. Thank you, Midnight Mike. Thank you so much. I know 30 is looking good. Thank you so much. I appreciate you. Day is awesome. so far. Mad World. Thomas T had comment of the day, quote, Bigfoot's videos are laughing at the Sallyport one. Well done. Well done. Thanks, Mad World, for coming in with the super chat to put that out there and giving Thomas T the credit for it. Melanie Little's left swipe and StreamYard is here. She's awesome. Thank you so much for your 20. And thank you so much for calling me your favorite creator. You are one of my favorite cupcakes. Don't tell the others. Just juicy. Will they use the Higgins footage to demand his phone records from his cell provider? Well, this, just juicy. Wish we could go back to my pretrial playlist on this. I don't even know how many videos, millions, like hundreds of hours, I think. There was a pretrial motion that was made to obtain his cell records, Higgins records. It was denied. I don't know if that's the one that went up on appeal, but the one that went up on appeal gave them a very small portion of Brian Albert's and Jennifer McCabe's, in addition to Jennifer McCabe's Google searches. Had they had this Higgins footage prior to the trial, that motion may have turned out differently. So good question. My guess is going to be yes. We'll see if it's granted this time by the judge. Buzzing for Truth, it's your birthday too? Oh, happy birthday, Buzzing for Truth. You, me, and Abe Lincoln. Thank you, Jessie girl, for hanging out for 5 months and for your wishes. I appreciate you. Sherry Ann, thank you. Oh, my all-time favorite lady in channel. You guys are you're making my day. Thank you, Sherry Ann. Gatling gun dystopian approach. David Reese is here. He changes his name every couple of weeks. As soon as they will let him change his name, he changes it. Oh, thank you so much for your wishes. I appreciate you and your super chat and always being here and being funny in chat. Crazy, but that's how it goes. Dr. Russell is the GOAT. She's watching from Norway. She's outraged too. Thank you. Thank you, Allie, for your super sticker. Craft-tastical. Is there any chance that the trial would go ahead on April 1st with all this additional testing, witnesses, etc.? Likely not. It will likely be pushed a little bit, I imagine. I mean, look, we're already at February 12th, and it's we're 6 weeks away. I think there's going to be additional time. I think it's not going to happen on April 1st, but if it does, I'm here. We're not going anywhere. We're here for it. That's why the team has to keep getting bigger. Wouldn't it be wild if Judge Canoni finds a reason to deny Mark Bettero's Pro Hac Vice application? I mean, will she say there's not enough seats at the table? The table's not big enough? Because during the first trial, when the defense made a motion to have Craig Bates, their tech guy, for lack of a better term, their expert, he's amazing. He did a show with me one time. He came on my show. Love Craig. They made him sit at like a little TV tray table, the kind that, we had in the 70s when we were like eating, when TV dinners were first invented, and you had to have that fold up TV tray table to watch TV and eat your TV dinner. Like that's what they made him sit at. They wouldn't let him sit at the table. The judge wouldn't. So we're going to need a bigger boat. We may need a bigger courtroom, and we may need some bigger defense tables, because Karen Reed is fighting for her life, and she's entitled to have as big a defense team as she wants, in my opinion. Victorious, thanks for the 5. She thinks, hey, how did I come to this? Oh, yes. Dave Matthews Band is applicable here. Gray Street, one of my favorites. Oh, I love it. Love it. Thank you, Victorious. Kathleen, thank you so much. 120-year-old 128 Aquarius. Thank you for all that you do. We're so empathic, aren't we? More geniuses born under the sign of Aquarius than any other. Just thought I'd point that out. I'm just a girl in the world. Thank you. It's rain in motions. Yes, it is. Oh, yes, 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 it is. Rainy day. Rule 14, expert opinion evidence. Such discovery shall include the identity, current CV, and list of publications of each expert witness, and all reports prepared by the expert that pertain to the case. So that is what Rule 14 provides. I think you're talking about the ARCCA stuff, right? Because you just put that in at 413. So this is recent. And so that is what is required under Rule 14. Current CV, identity, list of publications, and all reports prepared. Right. They want everything. The Commonwealth wants everything that the feds gave the ARCCA experts to do their analysis. And the defense is not privy to that. And neither is the Commonwealth. So we'll see. This will be an interesting motion. I can't wait to see the fiery opposition. I mean, it seems like pretty clear that Bobby Alessi, I'm calling him Bobby now, Bobby Alessi's expertise is in expert witnesses, because he's a civil litigator and I am a civil litigator. And no shade to you criminal defense attorneys, but we civil litigators see a lot more expert witnesses than you guys do. We just do. Because everything that we do requires experts, accident reconstructionists, doctors. We're paying people all the time to come in and testify. Some doctors if you get a neurosurgeon can charge you 20 grand to come in just for a day of testimony, because think about it. They have to put off however many surgeries they could have done that day. And so civil litigators are very adept at expert witness cross-examination, direct examination. You saw Alessi. He was like a master. The way that he directed Marie Russell on the stand and the way he made it simple for us to understand. There was no jury there, but we understood it. He was methodical. It was like a master class. We can see that that is his expertise. I'm imagining that he's fired up on his computer already, getting this thing ready, and his staff of however many he has working with him. The straining of credulity. Thank you. Thank you. True Crime Grammy, thank you very much for tuning in. And to your newest grandbaby, Charlotte Grace Lottie, born today. Oh, I love the cycle of life. I love that. Oh, I love it. Congratulations. That's what a beautiful name. Charlotte Grace. And you're going to call her Lottie. Oh, I love it. Not to sidetrack, but Lottie reminds me of, if you guys have not watched Yellow Jackets, you have to catch up on Yellow Jackets because the new season is coming out soon. It's on some streamer. I'm not sure what, but it is freaking awesome. I love Yellow Jackets. Tell me if you like Yellow Jackets in the chat. Thank you. Thank you, Miss Adventurous Bookmouse, for your super chat. We'll get back to these, but we still have a lot to do. Marcello is here from Argentina, and he says Bev can easily allow the motion to impound, but she thinks she's going to die if she allows the pro hoc vice motion out of court. It's bothering. Yeah. Yep. All right. Moving on. We'll see how the defense, it'll be interesting to see how the defense responds to that. But like I said, it's facially insufficient because there is no affidavit attached to that motion that I can see. It's not on the docket because look what I did. I even printed out the docket. I printed it out. Moving on. Moving on to motion number 499. Or docket number 499, defendant's motion to exclude the testimony of the Commonwealth's witness, James Crosby. This is a good one. I need 499 and 500 on deck. Because guess who's coming in with the deets? Dr. Marie Russell has submitted an affidavit. She's angry. Well, she should be anyway. I think she's mad because remember, wait, no, that's not the right one. I didn't want that one. I wanted 499 and 500. Here's 500. They tried to say that Dr. Marie Russell was not qualified. Wait till you hear the snark in this one. Where is it? Here it is. She's like, really? Uh-huh. You think I'm not qualified? Let me tell you a little something about your expert. All right, here we go. This is docket number 499. 499. A lot of filings in this case. Motion of the defendant to exclude the testimony of the Commonwealth's witness, James W. Crosby, MS, PhD. Now comes the defending Karen Reed and respectfully moves this honorable court to exclude the testimony of James Crosby, MS, PhD, concerning the medical cause of injuries to the right arm of the decedent, John O'Keefe. Exclusion of the testimony is compelled. Just made me think of a line from a movie. You know what this is from? The power of Christ compels you. The power of Christ compels you. Every time I hear the word compel, I have that screaming in my head. Power of Christ compels you. Okay, sorry. Exclusion of the testimony is compelled because it fails each of the two main prongs of the Daubert-Lanigan inquiry: qualifications and ding, 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 exorcist. Yes. No, wait, Ms. Mojo Risen was first, I think. Wait, we have a Ms. Mojo Risen and we have a Mrs. Jim Marson? That's crazy. Oh, but Allie was here. I think Allie got it first. Allie Guz. I'm a huge Doors fan. I have a friend who, when we were in high school, she used to bake Jim Marson a birthday cake every year, and we would have birthday cake for Jim Marson in the cafeteria. I'm not kidding. HBO is Yellow Jackets? Okay. Awesome. Where is that Exorcist? I don't know. The power of Christ compels you. Okay. All right. Here we go. Here's why. Crosby should not testify because he fails each of the two main prongs of Daubert-Lanigan: qualifications and methodology. Methodology. Whose favorite word is methodology? Is it Showtime? Maybe it's Showtime. Stephanie's like, well, it is Showtime. Thank you. Yellow Jacket's on Showtime. Sorry, I misspoke. Stephanie's like, well, you did say it was soup night. Just didn't know you meant pea soup. Haha. The Exorcist. Yeah, they did use pea soup in that. Yep. Olivia, you know what else is disturbing? Oh, Olivia, so many things. So many things are disturbing. She says, Brennan has been throwing around Crosby's name since fall of last year, meaning he clearly had a report from him by that time, yet he just turned it over a few days ago. Yes, we're going to find that out. We're going to find that out. In fact, I think in this motion, they say that he was hired before the first trial, but let me get there. Hang on. I thought my recollection may be faulty, but let's get there. Methodology, Hank Brennan's favorite word, toss around during his argument on why Dr. Russell wasn't qualified because of her methodology. That is, Dr. Crosby is not qualified to render the opinions he proffers. It is undisputed that he is not a medical doctor. He thus fails per se the crucial qualifications inquiry of the Daubert-Lanigan standard. This failure is not curable. In addition, the methodology that he invokes in his report is not reliable. Among other defects in his methodology, and you'll enjoy this word defects in a minute. Put a pin in that. Among other defects in his methodology, there is no showing that it is generally accepted in the relevant medical community. And the methodology is replete with errors, as is demonstrated in the affidavit of Marie Russell, medical doctor, dated February 11th, 2025, yesterday. Liza getting it done. I'm assuming it was Liza. I don't know my name is Liza. I might be giving her credit where some other credit is due. And if it's due somewhere else, I apologize. I just feel like Liza deserves a lot of props. You know, girl power and all that. And I don't think the boys would mind. I don't think the boys would mind that I'm giving Liza props. Which is submitted in support of this motion, because that's what you're supposed to do. You're supposed to support your motion with an affidavit of someone with knowledge that they swear to under oath. The failure of either Daubert-Lanigan prong requires exclusion of the proffered testimony. Dr. Crosby fails both prongs. Let's get out the button. Argument. The Commonwealth fails to and cannot meet its burden to establish the requisite qualifications of Dr. Crosby. They're going to go into great lengths to talk about why Dr. Crosby is not qualified. The crucial issue in Massachusetts for a Daubert-Lanigan inquiry is whether the proffered witness is qualified to give an expert opinion regarding the subject matter of his testimony. The subject matter of the testimony of Dr. Crosby is described in his self-styled preliminary report dated January 24th of 2025. That is his preliminary report. is the subject matter is the medical cause of the injuries and wounds to the right arm of the decedent. Footnote 1. For purposes of this motion, the defense has redacted various photos in the Dr. Crosby report to account for lividity and personal information stated on the hospital wristband. Ooh. On June 18th of 2024, this court was clear and emphatic. And when they say this court, they mean Judge Canoni. On June 18th, 2024, this court was clear and emphatic in its statement about the foundational qualifications a proffered witness in Massachusetts must possess before he or she can opine on the medical cause of an injury to a person. Such person must be a medical doctor. Specifically, on that date, Your Honor ruled, and these are the words of Judge Canoni. Dr. Rentschler, though I have some concerns, it's clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Only an MD can do that. So I'm going to reserve ruling on the rest of his testimony. There are certain things he can testify, and I'll hear you again before he testifies next week. Let's just proceed with the trial today. And that was during the June 18th, 2024 voir dire testimony of Dr. Andrew John Rentschler. That's right. I was correct. There was a day of voir dire testimony. And again, footnote 2 says, the defense could not locate a transcript of this ruling. As a result, the defense transcribed the video clip of the ruling, which was made in open court. The video clip is located here on YouTube. Look at that. Dr. Crosby fails this rule of law stated by Your Honor. His failure cannot be disputed. Dr. Crosby's report and his accompanying CV clearly show that he's not a medical doctor. Rather, these documents demonstrate that he merely possesses a Master of Science degree from the College of Veterinary Medicine and a PhD in veterinary medical science, both from the University of Florida. Neither of these are or even come close to a Doctor of Medicine, MD degree, or being a licensed medical doctor. Nor is he an odontologist or doctor of veterinary medicine. Oh, this is going to get good. Ready for the snark? Moreover, Dr. Crosby concedes in his report that he is not a medical doctor, stating, I am not a physician. Dr. Crosby then appears to express awareness of and sensitivity to this failure of qualifications. He unsuccessfully attempts to evade this shortcoming by raising a straw man argument that he should escape this failure because this case is not about the treatment of the wounds on the right arm of the decedent. There, in his report, he says, quote, I am not a physician. I am not licensed to treat injuries or illnesses in human patients. However, this case is not about the treatment of victim John O'Keefe's injuries or wounds. Thus, any opinion regarding the medical treatment of Mr. O'Keefe is inapplicable to the issues at hand, irrelevant, and has no impact on my opinions or the opinions that have been asked of me in this case. Yeah, if you get bit by a dog, you shouldn't go to the vet. The unilateral manufacturing of a treatment issue out of nowhere by Dr. Crosby is flummoxing and nonsensical. First, the defense has never mentioned any treatment of the decedent. Defense witness Dr. Marie Russell rendered opinions about the medical cause of the wounds to the right arm of the decedent. She did not render any opinion on treatment. Second, the fact that this case is not about the treatment of the wounds to the right arm of Mr. O'Keefe cannot save Dr. Crosby from his lack of the requisite qualifications, nor can it be allowed to camouflage the fact that the import of Dr. Crosby's entire report is him opining on the medical cause of the wounds to the right arm of the decedent, something that he legally cannot do in the Commonwealth of Massachusetts. And notice how they're sneaking in little portions of the report because we don't have access to the report because it's not in the public court docket, but they're inserting portions of it into their motion. So it's giving us a little glimpse into what his report says. In this regard, his report states, Dear Mr. Brennan, this letter is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. I was asked to examine the evidence in this case, including images, reports, and the involved dog itself, and determine, if possible, the potential source and nature of the defects. Hold on. The potential source and nature of the defects documented on the right arm of decedent John O'Keefe. I was particularly asked if I could determine to a scientific degree of certainty whether those defects were consistent with a dog bite or other animal bite. So it seems like Dr. Crosby went on the walkabout or the sojourn to visit Chloe. He also said in his report, the issue presented to me in this case is isolated to the nature, morphology, and likelihood of association between the defects documented on the right arm of Mr. O'Keefe and as to whether these defects are consistent with, to a reasonable degree of scientific certainty, a bite by a dog. Particularly at question is the likelihood of those defects being attributable to a German Shepherd type dog known as Chloe, who resided at the time of this incident at the residence near where Mr. O'Keefe was found, or by any other potential large dog alleged to be in the area. The residence near where Mr. O'Keefe was found. Dr. Crosby attempts to opine that the wounds on the right arm of the decedent cannot be caused by Chloe or any other large dog. Thus, his straw man discussion of treatment of the decedent as a distraction is very much beside the point, and it fails. Dr. Crosby is venturing well beyond his qualifications in attempting to make the sweeping determination that the wounds on the right arm of the decedent could not have been caused by Chloe or any other large dog. Is also illuminated by his own proclamations. The name of his consulting group is Canine Aggression, and the vast majority of his experience points to canine behavior. Additionally, Dr. Crosby's purported title, Certified Behavior Consultant, also underscores what is already evident. He does not have the requisite qualifications to opine on the medical causation of an injury to a human. And look, I'm in no way disparaging Mr. Crosby. Maybe he's called Dr. Crosby, James Crosby. He may be a very excellent expert witness in another case, in a case that has to do with canine behavior. In a civil case where perhaps a child is mauled by pit bulls and killed, and he could come in before they put the dog down, and he could examine the dog, and he could talk about the vicious propensities of the pit bull and what the owner of that pit bull should have known about those vicious propensities and the training of that dog. That is a case in which he may be a fine expert, but he's not qualified to testify, according to Judge Canoni, on the cause of an injury because he's not a medical doctor. That's it. End of story. We're done. We don't even need to read the next 25 pages, but we're going to keep going. It's not really 25 pages. I'm just kidding. The Dr. Russell affidavit also discusses the lack of qualifications of Dr. Crosby. Accordingly, because Dr. Crosby is not a medical doctor and thus cannot meet this court's medical causation prerequisite holding of the need to be a medical doctor pronounced on June 18, 2024 during the first trial, Dr. Crosby fails the crucial qualifications inquiry as set forth in Rentschler. Any testimony from him thus must be excluded from the upcoming trial on this basis alone. I mean, there's nothing more accurate or convincing in a motion like this than to use the judge's own words in this exact same case, right? I don't think there's a better argument than that. But just in case that fails, they go on. The court need not reach the other prong methodology of the Daubert-Lanigan inquiry to exclude Dr. Russell because of the failure on the qualifications prong alone dooms him. However, if the court proceeds to the methodology prong, the proposed testimony of Crosby fails on this point as well. And then they get into point 2. The Commonwealth fails to meet its burden that the methodology of Dr. Crosby is reliable. Neither Dr. Crosby in his report nor the Commonwealth elsewhere meet their burden of establishing the acceptance of the methodology employed by Dr. Crosby or the reliability of it. nor can they. The Dr. Russell affidavit provides details regarding the incorrectness, flaws, and other unreliable aspects of the methodology employed by Dr. Crosby. Oh, I bet she was chomping at the bit to do that one, to draft that affidavit, including his application of the methodology. These include his erroneous wound directionality theories and other aspects of his wound discussions, lack of proper forensic foundation and protocol regarding photography of the wounds, and failure to properly consider canine DNA related shortcomings of the Commonwealth and its agents involved in the DNA process. So let's just put it all in there. Number one, he shouldn't testify because you, Your Honor, said only doctors can testify about cause of injuries. But if you want us to move on to prong two, let's go. Let's go. On the jurisprudential front pertaining to the Dr. Crosby report, the defense's legal research did not discover any relevant Massachusetts state cases on the admissibility of bite analysis by a non-medical doctor, specifically regarding dog bite wounds inflicted on humans. The extra jurisdictional cases are those involving human and not dog bite matters, and proffered experts who are either forensic odontologists, practicing dentists, or professors with like credentials. And then they cite a Michigan case about human bite marks, and then a Wisconsin case, human bite mark identification. Both of those experts, one was a forensic odontologist, one was a dentist. Even then, when courts do admit human bite mark evidence on humans, the methodology the experts in these cases followed, those practices recommended by the forensic odontology community, including dental molds and the overlay method, in contrast to Dr. Crosby's self-styled and ad hoc methodology. You can read a little bit about other methodologies there if you like in other cases. At issue in this case is the cause of wounds to the right arm of the decedent, and the undisputed fact here is that Dr. Crosby is not a medical doctor, he is not a forensic odontologist or a veterinarian, and he does not appear to have worked with any of these professionals or a medical examiner in any aspect of his process. In other jurisdictions, states that do admit bite mark analysis do so under circumstances where the witnesses involved possessed expertise and the requisite qualifications in forensic odontology and dentists, and many of them worked in conjunction with a medical examiner. Moreover, our research did not reveal any Massachusetts or other case that has admitted testimony or evidence with regard to a dog bite and whether such bite inflicted a wound on a human using Dr. Crosby's methodology. Dr. Crosby does not even allege, let alone establish, that his purported methodology is generally accepted in the relevant medical community. This general acceptance concept is a key prerequisite of the Daubert-Lanigan standard, and in the alternative, general acceptance precept set forth in Massachusetts common law. As a result, the Commonwealth fails on this point as well. The thrust of Dr. Crosby's report appears to be based heavily on odontology matters, even though Dr. Crosby is not a forensic odontologist or veterinarian. That shortcoming aside for the moment, the scientific community has long questioned the reliability of forensic odontology in a legal context, no matter the qualifications of its proponent. They go on to talk about some studies. But even more applicable to Dr. Crosby's report is the fact that bite marks under non-ideal conditions have little published data, and it's unclear if forensic odontologists can identify the origins of these marks under these conditions. Dr. Crosby fails to articulate any concern over the potential error rate or other aspects of unreliability of his measurements due to these non-ideal conditions. Dr. Russell importantly noted that when a human is attacked by a dog, it is not a static situation. In this situation, the adult's arm moves as he attempts to get away, and his arm would be bending and moving up and down. Additionally, if an adult was wearing clothing, as the decedent was, these measurements likely would be altered even further. The movement changes the nature of the infliction of the wound. Dr. Crosby fails to account for this dynamic environment. An adult moving to get away from an attacking dog, which would affect whether there was a complete bite mark and the measurements of such bites. This also renders Dr. Crosby's entire methodology inaccurate and unreliable. Even under the most ideal conditions, where there is a complete and clear bite mark analysis is still not sufficiently reliable. And here are some cases to support that position. Some peer-reviewed articles, etc., etc. We're going to read Dr. Russell's affidavit, so we don't need to discuss it here. In addition to the absence of a demonstration in his report of general acceptance in the scientific community of the use of forensic odontology and bite mark analysis, Dr. Crosby's report suffers from still other defects. Remember that word, defects. In 2016, the American Board of Forensic Odontology published a bite mark methodology standards and guidelines report. And they attached a copy of it. In it, they discuss various methods to document bite size evidence, including taking saliva swabs of the bites. Okay. In it, they discuss various methods to document bite site evidence, including taking saliva swabs of the bite site, impressions of the surface of the bite mark, and tissue samples. While Dr. Crosby cannot access any of these samples due to the DNA failures of the Commonwealth, it underscores the inaccuracy of his methodology. Yeah, right. They didn't take tissue samples from John O'Keefe's arm. Or saliva swabs of the bite site, or impressions of the surface of the bite mark from the arm. They didn't do that. Nowhere in Dr. Crosby's report does he account for the absence of tissue or DNA samples from the wound of the decedent, and nowhere in the ABFO bite mark methodology, standards and guidelines, does it advise using a surrogate, such as a hospital bracelet of unknown origins, to attempt to accurately measure the injuries and wounds of the decedent. This methodology, trying to transfer the measurements and apply them to a human wound, is undocumented in his report. Also, in the Dr. Russell affidavit, Dr. Russell highlights the lack of support in Dr. Crosby's report for his methodology of using a hospital band instead of an ABFO ruler in assessing the wound on a human. So he's not using the proper tools. Furthermore, the dog, Chloe, examined in Dr. Crosby's report, would have bit the decedent on January 29th of 2022. Inexplicably, the Commonwealth waited almost 3 years to analyze and measure the dog's teeth in January of 2025. Dr. Crosby fails to address properly the scientific concerns that Chloe, having aged almost 3 years, could very well have experienced changes to her teeth, jaw, shape of her bite, and other aspects of her dentition. Relatedly, it is apparent that the Commonwealth retained Dr. Crosby in early 2024. Early 2024. That is before the first trial. That's where I saw it, Olivia. Because there's an invoice attached from January 29th of 2024. But waited until December of 2024 to apparently take bite impressions from a dog they claim is Chloe. Interesting? Bueller? Anyone? This apparent strategic waiting boomerangs on the Commonwealth and adds to the unreliability of Dr. Crosby's methodology. Interesting. Yep. Just wow, Olivia, just wow. As discussed, Dr. Crosby's methodology and application of methodology in trying to exclude a specific dog, Chloe, or any large dog from being the medical cause of a wound to a person is unreliable. And here's a whole bunch of reasons why. The NAS report revealed that it has not been scientifically established that one's dentition will transfer a unique pattern to human skin, or that the pattern would be maintained on the skin. And here's something that happened in Minnesota in 2016, and basically, bite mark dentition is junk science without saying that. Even the Commonwealth itself appears to have looked with disfavor upon the methodology of Dr. Crosby. On June 21st of 2024, during the testimony of Dr. Russell, Attorney Lally asked Dr. Russell if she was familiar with the 2009 NAS report, though he incorrectly referred to it as the NAS report from 2008. Attorney Lally himself referred to the forensic odontology section, the examination of bite marks, as, quote, not a reliable science, end quote. Well, I don't know. It's not a reliable science, but now you want to rely on it? Okay. You go on with your bad self now. Go on with your bad self. Attorney Lally questioned Dr. Russell on the practice of matching the mold of a bite mark to a human wound and noted the unreliability of the method has led to questioning its value in scientific objectivity. Additionally, the Commonwealth must not be allowed to state that support for Dr. Crosby's purported methodology is buried somewhere listed in 6 pages of random references and materials. There, Dr. Crosby disingenuously lists these as reference and materials consulted that may affect my opinions in this case. This attempt to camouflage whether he actually used any reference or material he lists and for which proposition on his long list by the permissive use of may is improper. The very purpose of an expert needing to prepare such a list is so that the opposing party can know what sources the witness has considered and is relying on for the propositions in the reported issue. The fact that his entire report is bereft of one footnote exacerbates this fundamental and scientific failure of his reported methodology. This malbehavior, well, those are words you don't see very often, but I like it. I'll allow it. This malbehavior of Dr. Crosby of listing pages and pages of seemingly endless materials without regard to whether they support any of the propositions in his report not only deprives the court of properly performing its gatekeeper function, well done, but it also imposes an undue burden on the defense. I need to take a quick run over here just to get my Gatorade. So give me a second. Talk amongst yourselves for a second. Getting parched and I need more Gatorade. All right, I couldn't find my chapstick. It was like a whole thing. Okay. Just want to say, I'm not sponsored by Gatorade Zero, but I just want to say that, listen, Gatorade Zero, your best flavor is cucumber lime. Cucumber lime. Why is it so hard to find? Cucumber lime Gatorade Zero is like impossible to find. So I have to drink. I like the cherry one too, the white one. It's like cherry. So there's that. All right. Moving on. Somebody wants to know if Chloe, I don't know where Chloe is. I don't know if Chloe was in Vermont or Texas, but they did invite they invited the defense to go with them and they declined. They said, no, we're not going. So they did. Yeah, it's cucumber lime. It's like a light green flavor. They also have like some weird green apple flavor that's not so good, but Gatorade Zero, I rely on it for my hydration. I know it's probably going to give me cancer like everything else, but whatever. Hard to find. So the second favorite is the cherry one that is like clear because it doesn't make if I was drinking blue Gatorade or red Gatorade while I was talking to you, my tongue would get red or blue. Can't do it. All right. Gatekeeper function, buzzwords, court likes. That is, the defense would be required to read all the listed materials just to try to ferret out which ones may be applicable. Clearly, Dr. Crosby should have footnoted apt references in the text of his report. Did Paul O'Keefe go with him, I wonder? He should not be allowed to do a data dump of references and obscure the inquiry for all. This is yet another reason why the Commonwealth fails to meet its burden of proffering a methodology, fails to proffer a methodology that is generally accepted in the relevant medical community, and otherwise fails to proffer a methodology that's reliable. In the alternative, should the court not grant the defense's motion on the papers to exclude the testimony of Dr. Crosby based on his lack of qualifications and his unreliable methodology, the defense requests an evidentiary hearing to establish the failure of the Commonwealth to meet its Daubert-Lanigan burden regarding the testimony of Dr. Crosby. So either exclude him on paper or let's go. We want another Daubert hearing. Let's do it. XOXO. Conclusion, Dr. Crosby is not a medical doctor. On this basis alone, his testimony should be excluded as he fails to meet the first and crucial prong of the Daubert-Lanigan standard for the reason expressed in Your Honor's June 18th ruling during the first trial. In addition, Dr. Crosby's proffered methodology is not generally accepted in the relevant medical community and is otherwise unreliable. For these reasons and for the other reasons stated above, Ms. Reed respectfully moves this court to exclude the testimony of Dr. Crosby concerning the medical cause of injuries to the right arm of the decedent on the papers and without the need for an evidentiary hearing. In the alternative, should the court not grant the defense's motion, we'll take a hearing. Thank you so much. XOXO, Bobby Alessi, DLA Piper, New York, New York. But wait, there's more. But wait, there's more. Because the best part of that motion is the affidavit of Dr. Marie Russell. Do you want to hear it? Do you want to hear it? I can't believe I broke this tripod. It's like I don't know what it did. All right. You can hear me okay though, right? Alessi fan club, are you all here? Is the Alessi fan club here? Septic Hank the Tank coming in, says have a drink on me. ACDC, you deserve it for all you do. Thank you so very much. Samantha Jones is here from Sex and the City. Thank you so much, sweetheart, for your super sticker. Kelly is a Boston 2L, and you're my favorite professor. Happy birthday. No way. Where do you go to law school? Where are you in law school? That's amazing. That's amazing. Year 2 is, I don't remember law school so freaking long ago. Thank you so much, though. I'm glad. Hopefully you are learning something. Hopefully you are learning something because you know what? They don't really teach you how to be a trial lawyer in law school. They really don't. Learning how to be a trial lawyer is a very separate and distinct set of skills. And the only way you're going to learn it is by watching it. So good. It's a good thing that you're watching trials. I used to watch Charles in my spare time. I would just go to the courthouse and just sit around and watch Charles. And it's the only way you learn. Those are skills they don't teach you. Adam Lally's resignation is back. Thank you so much. Bo, did you change your name back or did someone steal your old name? Thank you very much for your, whoever you are, for your super chat. And look at Tom CPU became a member. Thanks, Tom. Tom, doing the hard work at the boots on the ground. Appreciate you. GV, I never want to form opinions of defense attorneys based on their clients, but Mr. Breenan logic reminds me of why Whitey Bulger being crime boss and federal informant at the same time. Interesting. Yeah, I mean, defense attorneys don't, I guess they do to a certain extent pick and choose their clients, but got to pay the bills, right? Oh, thank you, Tom. You're loved by so many. Happy birthday. Thank you. Thank you so much. I love your sister too. Your sister is a big part of this community. And it was nice to meet her and you. Well, I've met you a couple of times, but meet your sister at the, the thing. Jazia, thank you so much for your birthday wishes. And hope you're having, you're fantastic. Thank you, Jazia. Clay's nanny is here. My granddad said, there's the beautiful day, lady. Happy birthday. Clay's nanny is here. Well done. Well done. Let me tell you something, honey. Dr. Russell. Yeah, that's what we're going to hear. This is going to be good. I don't know if I can do a Dr. Russell impression, but I don't know if she needs to. She doesn't need to be impersonated. She's queen. Well, no, the queen is Queen Tanis Yannetti. Queen Tanis is my queen. And she's my queen. Dr. Russell, there's this, I don't know. Well, maybe Dr. Russell is like the matron. Maybe she's the matron saint. She's the matron saint of the Karen Reed trial. I've done it. I've done it. I've coined the phrase. I'll allow it. You can use it. Dr. Russell is the matron saint of the Karen Reed trial. Thanks, Yuriy. Your birthday was February 6th. Thank you, Yuriy. Happy birthday, Aquarius. Thank you. Kelly Jane, thank you. It's your birthday today, too. We have a lot of February 12th birthdays in the chat, along with Charles Darwin, who was also born. Okay, Kelly Jane, you, me, a couple of other people. It's their birthday day. Abe Lincoln and Charles Darwin. They do say there's more geniuses born under the sign of Aquarius than any of the other. I'm just saying. And also, it's a full moon today. So, all the feels and all the crazy. And this is supposed to be like a big full moon today. So happy birthday, Kelly Jane. Hulda, thank you so much for gifting 5 memberships. Thank you so very much. You're so kind and generous. We have the best group here. We really do. Best chat on the internet. We really do. Piney Woods says, whoop, you're awesome. Thank you, Piney Woods. No, you are. Emma says, I'm not a dog bite expert, Jim. I'm not a doctor either. No, but listen, if a bunch of pit bulls killed a child, he would be a great witness to have. From Louisiana, extra vowels. It's just Joey. Oh, just Joey. I like it. Joey. I like it. There's a little French in there. I like it. Just Joey. That's awesome. Thank you. Yes, I hate mispronouncing things, and I do not mind corrections in pronunciation. Look, I've learned how to pronounce Quincy. I've gotten a lot of my Massachusetts pronunciations correct. This has got to stop. Hank's Book of Methodology says, I hope no one gets motion sickness from me. Method of Motion's busy now hitting off the record notes from Vanity Fair. Breenan. Thank you, Hank's Book of Methodology, for tuning in and for Team Brittany, gifting another 5 memberships. Thank you, sweetie. You're very sweet. David Reese, Lally argued at the first trial that bite mark identification was not reliable. Yeah, you must have put that in there. It must have crossed over from when I read that part, and you know it. Thank you, Lisa. Thank you, Lisa B. Jeepin. I'll allow it. Thank you. Thank you for thanking me, for thanking you. Thank you, Marie Louise, for tuning in with your super chat. And more gifted memberships. Look at this. Team Brittany gifting 5. Another 5. Come on, girl. Stop. And Shari gifting 5. You guys are amazing. You're amazing. Let's look at Dr. Russell's. What, if anything, affidavit? I don't know. Is that all we're going to have for today? Maybe. Will I get my soup for dinner? No soup for you. I think there's a Seinfeld quote for every situation. Every single situation. I think there's a Seinfeld quote. I can definitely think of one for every situation. Yes, Cusco. We need another reading from Melanie and Will of the Galore with Massachusetts accents. Yeah, that was funny. That was funny. Thank you, Laura. Thank you. Okay. Dr. Russell is back. She's mad as hell. She's not going to take it anymore. How dare you? How dare you? How dare you come for my qualifications? Because now I'm going to give you a whole bunch of pages about your alleged expert and why, in my expert opinion, because by the way, Judge, you've already qualified me as an expert. So now here I am as an expert telling you why their expert is not an expert. You dig? Hank is definitely not sponge worthy. Well done. Well done, Laura. Well done. Russell's revenge. Russell's revenge. I know. When I was making my thumbnail earlier today, because yesterday we were talking about the Alanis Morissette song, Right Through You. And it was all about, coming back with my army and all this ammunition on my back. And I see right through you and I see right through you. And I had to Photoshop Mark Betterow in there. And I had to Photoshop Alessi in there. And then I was like, wait, I need to get a picture of Alan with his beard. And so I had to Photoshop that whole thing in. And now the army keeps growing because now I got to put Marie Russell in there. I got to put Richard Green in there. There's a big army here. It doesn't take a village. It takes an army. Who's changing their name to Russell's Revenge? I'll allow it. Russell was so insulted when Brennan accused her of lying. Yep. Oh, it's bittersweetest. I said that earlier. It was bittersweet. It was bittersweet. Here's another funny coincidence. I know it's a long stream, but I haven't wandered that much from the topic today, but I'm going to wander a little bit now. It's bittersweet that that Mark Betterow is joining the defense team because he's my guy. He's my partner. He's my bouncing off of things. We would do shows together, and he would talk me off the ledge and, make me know that I'm not crazy for thinking the things that I would think about what was going on in this case, in this trial. And it's a little bittersweet. I'm here alone, but it's okay because I love you and you guys love me. You were also sad in the comments, oh, we miss his commentary. I'm like, but I'm still here. I'm still here. Don't you see me? So it's bittersweet. Also, Bittersweet Surrender is a song by, does anybody know? Bittersweet Surrender? Wait, I think that's the name of it. Hold on. I think that's the name of it. My Colorado friends might know this. Not Bittersweet Symphony, because that's another song that I was thinking of. Nobody knows it, huh? Oh, sorry. It's not Bittersweet Surrender. It's just called Bittersweet. It's just called Bittersweet. Anyway, Big Head Todd and the Monsters. Big Head Todd and the Monsters. And I went to college with Big Head Todd. So there's that in Boulder. Big Head Todd and the Monsters used to play at the Walrus, which was like a local bar. And it was fun. Yes, Carlene got it. Carlene is here. She got it. And Rubicon knows Big Head Todd. Does anybody know Big Head Todd? Or am I feel like, who is Big Head Todd? I went to college with Todd. And he didn't really have a big head. You know who's got the biggest head? Now I'm getting punchy because I've been sitting here for a long time and not being well hydrated. You know who's got a giant head? John Mayer. If you don't believe me, go look at pictures of John Mayer and Jennifer Aniston side by side. He has a giant head. It's giant. It's crazy. And it's giant. I'm going to plug this thing in. All right, Dr. Russell, coming in hot. Right? Publier du Monde knows what I'm talking about. OMG. No, he's my Johnny too. I am, there's no shade to John Mayer. I love John Mayer. Look at the poster behind me. It's the Denning Company poster. I'm going back to Vegas to see them again. Going back to Vegas to see him again. Don't worry. Don't worry. I'll be there. And I suggest that anybody who wants to go to the Sphere to go see Denning Company coming up. Okay, here we go. I, Marie Russell, MD, under oath, do depose and state as follows. The following facts, analyses, and other information are based on my own personal knowledge, and I could testify competently about them if called upon as an expert witness to do so. I declare that the following is true and correct to the best of my knowledge, and that I have no personal interest in the outcome of this case. In fact, I'm adding here that I don't even think she's being paid. She volunteered for this. Poor woman. Being put through the ringer by these twitidiots. I'm a licensed medical doctor and am currently engaged in the practice of medicine. I have approximately 30 years experience as an emergency medicine physician and as a forensic pathologist. Further information about my education, training, experience, and knowledge is set forth in my curriculum vitae, which is attached here too, which was previously submitted to the court. I also testified extensively at a Dalbert Lanigan hearing before the court in this case on December 12th, 2024 and January 7th, 2025. After this testimony, the court rendered a decision in which I was qualified as an expert on the subject matter of the medical cause of wounds inflicted to the right arm of the decedent, Mr. John O'Keefe, decedent. I have read and evaluated the self-styled preliminary report of Dr. James W. Crosby, MS, PhD of Canine Aggression Consulting, dated January 24th, 2024. Rainbow Rising, is your birthday too? That's awesome. Happy birthday. I mean, it's crazy because we have like, I don't know, we've had between like 6,500 and 7,000 people in here all day. And what are the odds? They say of two people like having the same birthday. And we've had so many people that have a birthday today too. So that's pretty cool. Dr. Crosby is not qualified to render the opinions and draw the conclusions stated in his report. Also, the methodology he uses to reach the opinions and conclusions in his report is incorrect, flawed, and otherwise unreliable. These two overall deficiencies relate to each other, meaning his lack of qualifications likely contribute to his flawed methodology and conclusions. Bang, bang. The subject matter of his opinions, of the opinions in his report, is the cause of the wounds to the right arm of the decedent. The opinions in this regard are variously stated on all of these different pages. For example, on this page, he states, quote, I was asked to examine the evidence in this case, including images, reports, and the involved dog itself, and determine, if possible, the potential source and nature of the defects documented on the right arm of the decedent, John O'Keefe. I was particularly asked if I could determine to a degree of scientific certainty whether those defects were consistent with a dog bite or other animal bite. End quote. Dr. Russell says, I have never heard of one stating wounds to a human as defects, nor have I experienced a non-medical doctor acting on his or her own to determine the medical cause of an injury to a person, ante-mortem or post-mortem. Roman 1, lack of qualifications of Dr. Crosby. Dr. Crosby is not a medical doctor, nor is he a forensic odontologist or a veterinarian. He does not appear to be licensed in any medical or scientific field or to possess any other professional license either. He also does not appear to have taken any nationwide examination for his stated specializations. I am unfamiliar with the 2 degrees he possesses in veterinary medical science. I have not heard of either in my 30 plus years of practicing medicine, including forensic pathology. He does not specify in his report any requisite education or training he possesses in the forensic examination of humans, including in the highly specialized medical topics of wound identification and wound direction in humans. He does not state in his report any training in the highly specialized and scrutinized areas of forensic photography. He does not state in his report that he worked with a forensic pathologist or a medical examiner for any matter addressed in his report. He states in his report that particularly at question, in quotes, is whether the wounds on the right arm of the decedent are caused by a dog named Chloe or any other potential large dog. But he then strays from that charge and claims that certain wounds on the right arm of the decedent are consistent with an I love this. I almost feel like she drafted this herself. I almost feel like she's like, give me a go at this. I want to draft it myself. But he then strays from that charge and claims that certain wounds on the right arm of the decedent are consistent with an engagement of some sharp or semi-sharp object. ... He does not state in his report any qualification that would allow him to make such a claim. In my experience, only certain medical doctors are qualified to make such a claim. I am one such medical doctor. Oh, yes, oh, yes, oh, yes, you are. You are the matron saint of the Karen Reed trial. Number 2, Roman 2. Lack of reliable methodology of Dr. Crosby. Yeah, we need a 5-minute laugh track. Hold on. Got to get the vocal spray. We do. They're going to regret badgering Dr. Russell. I know they are. This falls under, you better want what you wish for. You have unleashed Dr. Russell, and she's mad as hell, and she's not going to take it anymore. No, this is not the guy that came on with Brandy. No, that was I forgot somebody else that Brennan quoted directly. Dr. Kinsey, I want to say. Crosby, Kinsey. Yeah, I can see how you could get confused. Okay. I am one such medical doctor. Roman 2. Lack of reliable methodology of Dr. Crosby. There are numerous errors and other flaws in the methodology and application of the methodology described and utilized by Dr. Crosby in his report, which individually and collectively render his report medically and scientifically unsound, otherwise unreliable. This affidavit is not intended to address all of these flaws, but the ones I do discuss each render his report, and especially the opinions and conclusions in it, unsound and otherwise unreliable. Tripping Gauntlet says, you doubted my integrity, you will pay. From an overall structural perspective, his report is defective scientifically and medically. He does not footnote any source of authority in the text of his report. But wait, was it peer reviewed? Remember that? At the end of his report, he merely lists numerous references and materials that he states may affect his opinions in this case. He also describes his report as a, quote, preliminary response to your request. Neither of these approaches meet medical or scientific norms for the use he apparently intends for his report. Likewise, he does not provide in the text of his report any citation to any literature source which would show that his methodology or his application of the methodology under the circumstances of this case are in accordance with general acceptance in the medical or any scientific community. Dr. Russell telling him, you wrong. Jonathan Dean says he's a dog whisperer. Teresa McD says, I love her so much. Good Citizen loves her too. Aaron, we're not gonna take it. No, we ain't gonna take it. We're not gonna take it anymore. Well done, Aaron, well done. Likewise. No, I read that sentence already. Okay, next. Wound analysis methodology of Dr. Crosby. The subject of wound analysis, including wound directionality in humans, is a highly specialized area of the practice of medicine. Many physicians lack sufficient knowledge, training, experience, and skills to engage in this area, which is the subject of substantial training and many medical textbooks and peer-reviewed articles. Oh, I love she got in that. Peer-reviewed. Love it. I possess the requisite education, knowledge, training, experience, and skills in this area. The methodology and application of methodology by Dr. Crosby concerning the wound analysis of the right arm of the decedent are incorrect. First, he evaluates the decedent and his wounds as if they were the subject of a static environment, as opposed to the proper dynamic environment that existed when the decedent was being attacked by a large dog. He wrongly evaluates a dynamic human body like it was a hard plastic and static mannequin. The mannequin has entered the chat. For instance, he does not account for the movement of the various body parts of the decedent during the attack, such as the substantial flexing of his right arm, or the movement of his right shoulder to protect himself that would decrease the angle of the elbow and move the wounds closer together. The failure of Dr. Crosby to account for these movements renders wrong and unusable all the wound measurements in his report. Dr. Crosby wrongly applied his canine dentition measurements as a theoretical. Dr. Crosby wrongly applied his canine dentition measurements to a theoretical static right arm, which angle of the elbow crease never moves during a dog attack, according to Dr. Crosby's methodology, but remains fixed as it exists in the photographs he has in his report. He also does not account for the elasticity and compressibility of human skin, which also is not static. Wound measurements change as a result of the dimpling and bunching of human skin. Likewise, there are structures immediately below the skin, such as bone and muscle, that would be and look different during the dog attack. This static methodology approach by Dr. Crosby is medically unsupportable and incorrect and renders his measurements unreliable. Second, he wrongly bases his analysis on individual wounds or individual sets of wounds as opposed to the overall pattern of wounds. Third, the directional arrows he inserts into the picture of the decedent on page 1394 of his report are going in the exact opposite direction of how the wounds were actually inflicted. Because of this error in directionality of the wounds, his measurements and conclusions about the distance between the wounds are incorrect. It is therefore his analysis that suffers from a conflict in orientation. He must have said in his report, that there's a conflict in orientation. So she's quoting it right back to him. It is therefore his analysis that suffers from a, quote, conflict in orientation, end quote. It's like a smackdown. This is another flaw in his methodology. Fourth, Dr. Crosby's arch analysis methodology is incorrect. He claims that the arch is backwards if the wounds were inflicted by a dog. The direction of the arrows he shows is wrong relative to the arch he proffers. Again, these are failures of Dr. Crosby to account for the dynamic environment during a dog attack, and these failures render his measurements incorrect and unreliable. The only thing that would make this more amusing to me is if she just wrote, "You wrong, Dr. Crosby, you wrong." Fifth, Dr. Crosby does not account for the partial or incomplete bite scenario that is present in the wounds of the decedent. He wrongly assumes both jaws of the dog would be making compressions. He wrongly assumes both jaws of the dog would be making compression as opposed to glancing bites against the skin and less than all teeth impacting the right arm of the decedent. Nor does he account for the effect of the hoodie sweatshirt the decedent was wearing in making and discussing his measurements, conclusions, and opinions. These are yet more defects in his methodology. Yet more defects. See how they keep reusing the word defect because he kept referring to the wounds on John O'Keefe's arms as defects. It's masterful in a very nuanced sort of way. B, photography methodology of Dr. Crosby. Forensic photography requires proper qualifications and training. The use and application of forensic photography methodology is highly scrutinized and for good reason. There is no discussion in the report of Dr. Crosby about who took the photographs or how they were taken. It is obvious that at least one of the photographs is distorted and not a depiction of reality. This is the failure of proper forensic photography methodology. Desert Quill says, I can't tell you how much I love this. Gen X chick is like, she's trolling him. I love it. Also, there's no documentation of general acceptance in the medical community for the use of the hospital band Dr. Crosby applied as a substitute for the requisite American Board of Forensic Odontology two-dimensional ruler, which neither the photographer at the hospital nor the medical examiner for the Commonwealth used as they should have in photographing the wounds on the right arm of the decedent. Failures, failures everywhere. C, DNA analysis methodology of Dr. Crosby. Apparently it seems that he used the hospital band on John O'Keefe's arm as some sort of measuring stick, or a different hospital band. I'm not really quite sure, but layers of shades of onion. Yeah. Dr. Crosby attempts to make much about the supposed absence of dog DNA on the clothing of the decedent and how he believes this supports the absence of a dog bite. This application of forensic methodology by him is incorrect and unreliable. The Commonwealth did not swab the wounds of the right arm of the decedent for dog or any other DNA. I'm going to read that again, a little louder for the people in the back. The Commonwealth did not swab the wounds of the right arm of the decedent for dog or any other DNA. And there is no documentation of proper collection, handling, or chain of custody of the clothing of the decedent or the swabs used on the clothing. The DNA testing protocol for dog DNA employed by the Commonwealth and relied upon by Dr. Crosby in his report is based on a flawed foundation. As a result, this supposed absence of DNA claimed by Dr. Crosby in his report does not reliably support a conclusion that dog DNA was not on any wound of the decedent or on his clothing. Mic drop, walk away. Well done, signed and sworn under the pains and penalties of perjury this 11th day of February 2025, the matron saint of the Karen Reed trial, Dr. That is right, Dr. Marie Russell. Preach, sis. What do you think about that? Well, I didn't mean to do that. I meant to do that. Bam, bam, bam. I thought that was fire. Fire, too short. Thank you for your super sticker. Today would have been David Reese's grandmother's 110th birthday. Well, she has an amazing birthday too. Thank you, David. Thank you, Shari, for your happy birthday. Thank you, Mama Cass. Thank you for your super chat. Happy birthday. Appreciate you. Shaylin, thank you for your super chat. What the Duck has been a member for 3 months, and Hissy Fitz has been a member for 15 months. Glad to be back after a long course. Thank you. Thank you so much. Elizabeth, thank you for your super sticker. Nina is here. Thank you, Nina from Switzerland. Bev's going to have a busy weekend. Dream Team. She likes her weekends. You know, Nina, she likes her weekends. Thank you. Beth, thank you so much for your super chat. Piney Woods, thank you. Happy birthday. You're doing a yeoman's work today, Rockstar. Thank you, Piney Woods. Dennis the Menace, how much is Crosby PhD getting paid for his bill? Well, that's the thing. Why would they go and spend all this money on this expert that they know is not a medical doctor, that they know from the first trial? Well, you know, look, in his defense, Hank Brennan did not watch the first trial, but, you know, had he watched the first trial, he would have known that Dr. Canoni, that Judge Canoni was not going to allow any expert to testify about the cause of injuries if they were not a medical doctor. Hence, that happened during Dr. Crash Daddy Rentschler's voir dire. So they did use her words in their motion, which was very, 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 very wicked smart. Wicked smart. So why would Hank Brennan go and hire somebody who's not a medical doctor as an expert in the cause of injuries to John O'Keefe's right arm? It makes no sense. My opinion is because they couldn't find a medical doctor who would say that. They weren't dog bites. I'm just saying. Orwellian person says, I can almost hear AJ or someone angry typing this. Yes, yes. Brennan's hashtag value. Thank you so much for tuning in from Australia and for your wishes, your birthday wishes. Orwellian person says, I can almost hear someone angry typing this again. Well done. Colleen became a member. Welcome. I am one such medical doctor. Look at that. Changing her name. Changing her name during the course of this stream. You saw it here. I just couldn't help the name change. I am a Dr. Russell fan. Matron Saint, I'll allow it. Aussie Steve, in this very serious case, I'm loving the humor. Dr. Russell, you right, go girl. She is Mother Superior of the retrial. Even better. I don't know, Mother Superior or the Matron Saint. I don't know. I love to say like for the love of the traveling Mary, which is something we got from the Maya Kowalski trial, but you know, all the Catholic girl references are coming in. Thanks, Aussie Steve. Screaming Mimi Sue. Well, we miss Bettero. You are amazing. You can't be bad all by yourself. Thank you. Thank you, Screaming Mimi. Sometimes it's easier to do it by myself because when I have guests on, then I have to hold my tongue sometimes and I interrupt them, not because I'm being rude, but because I'm afraid I'm going to forget what I'm going to say. Clemency, one of the jurors will be on Turtle Boy's live show Saturday night at 9. That's awesome. So they're coming out, huh? The jurors are coming out of the woodwork now. They must be mad. I saw Christina Rex tweet. She talked to maybe 2 of the jurors. Is that one of them? I don't know, but I haven't had a chance to catch up on that yet because I've been here with you guys all afternoon. Dr. Russell, to quote a decorated dude, you wrong. Thanks, David. I stand firmly by my name. Dr. Russell is the GOAT from Norway. That's right. That's right. Patty Minko, thanks for spending the afternoon with me and for being here for 9 months. And Iceman is here. Dr. Russell is trooper Pauling, this Commonwealth expert. Human wounds here. Hold my beer. Thanks, Iceman. I appreciate you. I have some more questions over here. I mean, who knows? There may be something in the inbox. There may be some new droppings. We don't know. We just don't know. Denise, thank you so much for your Venmo and for thanking me for all that I do. Cherry, thank you so much for your Venmo. Lisa, thank you. Says, thank you for your Venmo. Says, free Karen Reed. Samantha wants to know if Bev denies Bettero's pro hoc vice, could he work behind the scenes as a consultant? I don't see why he couldn't. I don't think there's any good reason to deny him, but you never know in this trial. You never, ever, ever know. Excellent question. Yes, he certainly could. He just wouldn't be admitted to practice law in the state of Massachusetts on this case in open court. But thank you so very much for your Venmo. Jennifer is thanking me for all that I do. Thank you, Jennifer, for your Venmo. Oh, Sarah, you're awesome. Thank you, Sarah. Sarah and shock and horror. Amanda. Free Karen Reed. Thank you, Amanda, for your Venmo. Andrea, thank you so much for your birthday wishes. Marcy's iCloud. Wait, hold on 1 second. Samantha says, in your professional opinion, do you think Bev will allow any of these motions from the defense? She may call for a hearing on this Crosby motion. I don't think she'll deny that just on papers. I think she's going to have to allow them access to One Meadows and access to the vehicles so that they can do their own reconstruction. I think she's going to have to allow that one. I think that, I mean, listen, in the interest of fairness to the defendant having a fair trial, they shouldn't have to turn over the impeachment evidence, especially if under Rule 14, they're not required to. So I could see that one going their way as well. But again, it's like, I don't know that I would gamble on any of this stuff because you just never, ever, ever know what's going to happen in this case. It's whack. I've never seen anything like it, Samantha. Thank you again for another question via Venmo. It's a beautiful day in the neighborhood, says Cheryl. And thank you so much for your cash app. And B, thank you so much, B. Ann, for saying happy birthday. And Nina, thank you so much for your cash app. I appreciate you. Caitlin sent me a gift. Hold on, unwrap it. Oop. Can't unwrap it right now, Caitlin. It won't let me, but thank you so much for your memo. Barbara buying B Mac bought 5 matcha lattes. Thank you so very much. Beth bought 3 matcha lattes. Says happy birthday. Thank you. What? What? Are you kidding? Okay, hold on. So I have an amazing, as you know, behind the scenes Massachusetts paralegal who's amazing, and I'm not going to dox him or her, but said, Kevin Reddington just mentioned you in the Turk hearing. He referred to you as an attorney from New York who is far more credible than any of the other YouTubers. What? That's wild. That is wild. I wanted to cover the Turk hearing today because it was in Norfolk Superior, but it was going on at 2:00, and I had already planned this for 1:30. Oh my, was it recorded in any way? Or was it just on Zoom? That is wild. And I have been covering the Turk case, and that's crazy. And he represents Turk. He did? Really? Wait, was that on, like, was it as an aside, or was it Reddington? You're right. Reddington is wild. Yeah, Galore met him in court. Turk, this is the case that he was talking to you about. This is the case where poor Katie McLean was found in the pond behind the house. And he allegedly, Reddington, you're right. He allegedly confessed to, as such, strangling her. That is wild. Thank you for telling me that. Melissa, thank you, says, happy 29th birthday. We can't call Alessi Bobby because someone said on Twitter we have to have the actual dream team DREAM. So it has to be David, Robert, Eliza, Alan, Mark. Incredible. Thank you, Melissa. Great point. Just Joey bought me a matcha latte and said happy birthday. Then there's an anonymous 3 matcha lattes anonymously, because a lot of you people, a lot of you guys like to be anonymous. 3 matcha lattes, and Marie says happy 39th birthday. Thanks, Marie. Kathleen says happy birthday via Venmo. Thank you, Kathleen. You guys are too good to me. You're too good to me. And Kathleen, again, another thanking me for all that I do. You guys, I if I didn't have you guys or this channel, I would just be like screaming into the closet. Screaming into the closet. Okay, so she allowed the motion to impound. I knew that. So the Commonwealth made a motion to impound. That was docket number 498. We didn't pull it up, but it was basically they wanted to impound exhibits A and B to the Commonwealth's motion to exclude the ARCCA experts, which we did read. Judge Canoni signed it and dated it today. She allowed it. So that was impounded. Everything else I think we've done, right? We've done it all. We did everything today, you guys. Scott says, I like Kevin Reddington. He represents some awful people sometimes, but he can be very fun. Cool. He's even taking photos with free guarantee people outside of court, and he's John McCabe's lawyer. Yeah, I know. Yeah, I'm also a big fan of Larry Tipton. Larry Tipton got Petty McGee an acquittal on a bench trial by Judge Canoni, which was, the whole prosecution was ridiculous anyway. But Larry Tipton is also going to represent Brian Walsh, and a lot of the same players in Brian Walsh that are in Karen Reed. Thank you, Kay Schmidt, for your birthday wishes, and Tracy for gifting 10 membership. You guys are awesome. So this is going to be fun. It's going to be fun. It's too bad we didn't cover the Turk motion today, but I'll be catching up. Did they grant the motion for a change of venue? Because they wanted to change of venue. I don't think they're going to get it, but if that case is still going to trial, it's going to start on March 25th, and we're covering it because I don't think that Karen Reed is going to happen on April 1st, which gives us time to cover Dr. Harry Turk and the untimely demise of his late wife, Katie McLean. And I've heard from so many of Katie McLean's friends who are just, they have so many, nobody has a bad word to say about her. She was such a nice woman, and they all really, really miss her. Thank you, Samantha, for thanking me for answering your questions by giving me another Venmo. And Kirsten says, YouTube was never so addictive because of you. Thank you for your insight and coverage of the Karen Reed case. Oh, you're very, very sweet, Kirsten. We have a lot of Kirstens and a lot of Kristens here. So that is interesting. We also have a lot of Melanies in this chat. And Cindy B, thank you for thanking me and for being here for 14 months. And Amster 00. Thank you for keeping me company while I do AP. Absolutely, anytime. Kay Willis is here. She's a realtor and she can help you with all your real estate needs. South of Boston. Thanks, Kay. Fairy Raven gifted a membership. Shannon 1989 gifted. Is that when you were born? Is 1989? Oh, you're all babies. You're Aquarius too? Oh, Aquarius is the best, right? His next date is 3/11. Okay, good, good, good. All right. Thoughts, questions, comments, concerns before we wrap this 4-hour and 10-minute stream. I'm sure there's going to be more stuff that's going to be dropping tomorrow. So we'll cover more things tomorrow. Make sure you have your notifications set to all. Make sure you allow notifications on your phone. Make sure that you do all the things and stuff that YouTube likes. Hit the subscribe, hit the like, comment respectfully, be kind to each other. I think we covered it all, right? I'm pretty sure. But my voice is too tired anyway. So if there's anything more, we will cover it tomorrow. And, signs everywhere, signs. Man as hell, we're not going to take it anymore. Got that. Got the affidavit of Robert O'Neill. We got that. We did that. Did it. We did it already. Thanks, Nancy. Thank you. We're having soup for dinner. No soup for you. All right. I'm sure you're going to see you tomorrow, but you're going to want to set your notification because we got lots of things to catch up on. And I'm sure there's going to be more Karen Reed droppings. And Team Brittany's got to get in there with another 5. So welcome to anybody who's randomly gifted. There's going to be lots of things and stuff. And we got to debrief again. It's like every day is going to be a debrief till then. So it's a good thing that I'm not on the defense team. So I can sit right here in my house, in my studio, and talk to you every single day as you rage crochet, rage clean, do whatever it is to fuel your outrage. You guys are awesome. I love you. Thanks, moderators. Thanks for keeping it classy today. Thanks for making this one of my best birthdays ever. Thank you, Midnight Wife, for gifting 5 memberships. I love each and every one of you with all of my heart. My moderators are amazing. Show them the love. Stay cool, stay kind, stay classy. You can do it. I know that you guys can do it. It takes an army, it takes a village, and you guys are the village army. You are. And you're all amazing. Each and every one of you. Peace out, my friends. Until tomorrow, I say so long, farewell. Auf Wiedersehen, adieu. Good night, everybody.